March 20th, 2024. This is the Zoning Board of Adjustment for Madison, New Hampshire. My name's Drew Gentile. I'm the chairman of the board, and we will start the meeting. Why don't I ask Sharon if you'll lead us in the Pledge of Allegiance? Flags down here.
I pledge allegiance to the flag of the United States of America and to the republic which stands one nation, under God, indivisible, with liberty and justice for all.
Is there anyone here tonight for the Moscone case? I'm only asking because it's on the agenda, but actually it was approved for continuance to June. So if you're not here for the Moscone case, it doesn't make any difference. But as a courtesy, I didn't want you to be sitting here waiting for it to show up. Okay. We're going to take the cases in case order number this evening. That starts with case 23-12 for Andre and Erica Medeiros on Knight Road, and we'll proceed, just in order there. I'm just looking around just for curiosity. Bob, you here to represent the Board of Selectmen, or are you just here out of curiosity? Two roles? Okay. Okay, so
We want to validate that.
let's see, can I ask, let's see, you're officially recused from this case, so can I ask
Yes,
you
that's
to
correct.
take a seat in the audience? Okay.
Mark is not here.
And Mark's not here. Let's see, and we have, George, you're a regular, I'm a regular, and Sharon, I'm going to elevate you to voting status, so we have 5-member board tonight. Okay? All right, so is there any other preliminaries, Kate? We're all set, right? Okay. All righty, so let's proceed with case 23-12. Are you okay with that, Mr. Johnson?
I am.
Okay. All righty, so, well, we got a couple of things to take, a couple of formalities. Did we have already, we don't need to repeat all the formalities, right? Okay, so we're all ready to go. So in that case, right, so just for the information, we've already checked for conflict of interest. Well, actually, I need to check. Sharon, do you have any conflict of interest?
I do not.
Okay. Okay, so there's no conflict of interest. Waiver requests have been taken care of. There's no regional impact. So at this point, we will continue on with the statement of the case. So, Mr. Johnson, sorry to,
So I believe just a couple of housekeeping moves.
Sure.
Relative to this case, again, Matt Johnson on behalf of Medeiros, applicant 2312. At the first presentation, it was agreed that I could make my legal argument and it really would apply to each of them, so we didn't say, and you didn't have to say the same thing. I just make sure we're operating under the same ground rule. With that legal presentation relative to my legal arguments is applicable to each of the various applications, and now we're on to like the fact-specific aspect of each use of the property, just so that we can play. I mean, the legal analysis is included in the letter.
Right.
It's in with each application, so it is
That-
before the board.
that is correct.
Okay.
My only question is whether members of the public, I guess, well, this is a public hearing. Do we need to at least summarize those?
You can ask him to summarize them. The written is, as he said, in his letter.
Right.
My question would be, if you're coming from a meeting several months ago to tonight,
Yeah.
maybe good to have a
Just
short summary for tonight to carry
one or
over.
two sentence summary of your
Sure.
4 points for this, and then they'll apply to everything else heard tonight.
I mean, I stand by my letter, but at the high level thing there, I provided the board some analysis of why, under the language used in the ordinance, I don't believe that short-term rentals are excluded, and in fact is a permitted use under the ordinance. I also raised a couple of just constitutional challenges relative to the taking of the use of my various clients' properties, which I've also outlined in the order. But so it's really a twofold prong. One is just based on the language of the ordinance itself, and then second was based on the, just some constitutional arguments. The third argument, which depends on the property, is whether they are permitted because of a pre-existing non-conforming use analysis, but that's case specific to different applicants, and is not equally applicable across all of the applicants. Thank you.
Okay, that's,
Okay.
yes.
And so, as I believe from my notes from the Maderos matter, I made a presentation. The board has some questions. You open it up to public comment. Obviously, the board is free to do it. The only thing I had additional was just based on the outcome of the last hearing, was I wanted to hand up just a statement from the Maderos, which just attempts to answer some of the questions the board had, just to try to be efficient with the board's time, because I know we have a lot of these on here, so we're trying to give the board what it needs to at least be able to make a decision. Can I approach?
Yes.
And so I have 5 copies of this, and I'll just tell you it is the sworn statement from my client, just in terms of how they use the property, why they use the property. It has some of the house rules behind it, and also the covenants that they came with the property.
And just as a clarification, this one, there is no claim for grandfathering before,
Nope, that is accurate, although, and it's not a claim of grandfathering, and I'll submit this package in the next application, but I thought it was important for the ZBA to be aware of this just generally. There was some discussion at the prior hearing about, well, people need to do their due diligence and the ordinance changes, and, people need to be aware of that. One of my clients is a screenshot of the current, even, Madison website, and it says if you own a home in Madison that you rent out short-term or long-term, you may be required under state law to file landlord agent designated respondent affidavit form with the town clerk's office. For more information, visit the department tab, town clerk, landlord's agents, respondents information. So it's actually still just noteworthy that nothing on the town website, when you go to look and do any of that due diligence, suggests that you can't, as what the town's position now is, that you can't rent short-term. So I make that as a comment just relative to what is available if someone who is looking to move into Madison, potentially do short-term rental, is going to look on the town website. The town website seems to suggest even today that you can still do short-term rentals. So there's not a lot of detail to that, and I would argue it, frankly, somewhat, you can understand why some people would not realize they couldn't do it. And so I just make that point as well. Subject to that point, that's the evidence presented relative to the Maderos appeal 2312, and I'm happy to answer any questions, as are the Maderoses. They're here tonight. And we can take it from there.
Okay. Okay, by our rules of procedure, what we do for the public, we allowed the applicant to make a statement. He was not sworn in because he's been sworn in before. However, anyone else who wishes to speak to this will allow, now that there's been a pro statement, if anyone wishes to speak against this, you'll be allowed to speak. Then there'll be 2 rounds of rebuttals. Does anyone in the audience wish to speak to this case? Okay, those of you who wish to speak, please rise. Raise your right hand. Do you swear that the testimony that you give pertaining to this case will be truthful under the penalty of perjury? Okay. Then,
No way.
okay. You want to speak?
Can we have a chance to read this into the record so that the audience can hear? There's more statement.
Okay. Yeah, Jake has suggested we actually read this relatively short letter into the statement so that the public can hear this. This fits in with the statement by the adjuster. Just give me 1 second. We, Andre and Erica Medeiros, hereby state under penalty of perjury that we are the property owners of 81 Knight Road in Silver Lake, Madison. We purchased the home on July 8th, 2022 with the attached understanding of restrictive covenants, none of which state short-term rental restrictions. We started renting short-term on September 30th, 2022. It is primarily used as a short-term rental property as it was intended with our 1031 exchange from our previous property. Therefore, we only use it ourselves 2 times a year for approximately 2 to 3 nights in each state. The house is advertised as 5 separate sleeping rooms with a maximum of 14 guests per stay. Typically, our rentals accommodate about 10 guests, consisting of 8 adults and 2 children on the average. This house has a 1,000-gallon septic, which is roughly 4 bedrooms. We only ever received 1 noise complaint from a neighbor at the very beginning of our rental history. She had reached out to us via Airbnb, and we apologized for the disturbance and immediately contacted our guests. They were understanding and quickly lowered the noise. As confirmed by our neighbor who originally reported the complaint, there was not a peep heard for the remainder of their stay. Although we were not made aware of it, we recently received a letter from the chief officer about 2 calls that were made. I assume that's the chief of police. About 2 calls that were made for our property, one of which was during our very own stay at the house with our family and young children, which we would argue was an exaggerated complaint. Attached is a copy of our house rules and a copy of the Airbnb reservation log showing our first rental on September 30th, 2022. Meals and room taxes are paid to New Hampshire Department of Revenue directly by Airbnb. Okay, thank you. Okay.
Nick Borelli, Madison. Mr. Chairman, thank you for the opportunity to provide recent discovered information regarding the property that was discussed by this board on November 23rd, 2023, at the ZBA hearing here on 81 Knight Road. A testimony by the applicant's attorney was that the property was a 1031 exchange process, rental property, and the property insurance will support the claim this was always to be a rental income property. According to Carroll County Register of Deeds, the property was sold on July 8th, 2022, and mortgaged was recorded on July 8th of 2022. A second mortgage on the property was recorded on July 19th, 2023. Both mortgages are residential type mortgages with a second home rider as opposed to a rental income investment mortgage. Both companies issuing the mortgage, Sierra Pacific Mortgage and New Res LLC, are residential mortgage lenders firms only. The second home rider requires the borrower to keep the property available primarily as a residence for borrower's personal use and enjoyment for at least 1 year after the date of the second home rider. The 2 active mortgages require the owners to use the primary property. I'm sorry, I apologize. The property as the borrower's personal use from July 20 of 22 to July 20 of 24. This is testimony from the abutters, neighbors, that they never seen or met the owners until November 2023 at this ZBA meeting, and the turnaround of the renters is almost every weekend. As of March 20 of 24, there are a total of 75 past stay reviews on Airbnb, and the property is booked for 12 weeks combined April through August of 2024. So I'm confused as the owners state one intended use as rental property only and presents their intended use as a second home to obtain their 2 mortgages. Please take this in consideration, as this is confusing testimony to me. May I move forward?
Yes.
Here's my letter. Here's the proof.
Can you see what it is that he's
Yes, you
purporting
may.
to be my client's mortgage?
Here. Pass this down to Kate.
To Kate.
Okay, questions from the board? Okay, thank you. Okay.
We would just say that my clients would just say they refinanced, but it wasn't a second mortgage. But, and I'm not sure how this is relevant. You want to say anything about one of these hearings?
Okay, you can pass that down to Kate. Okay, does anybody else wish to speak to this, Mr. Boyd? I think.
Boyd, 5590. I'm here as an zoning officer and also the ordinances. I won't go back through that. Back in November, we brought that the ordinances changed in March to prohibiting transient occupancy. It was before they bought the house, before they started renting. So it was illegal at that time. Excuse me. As a butter, as I stated back in November, it's nonstop every weekend. Other than that, there are people at the house staying less than 31 days, so it is transient. And it doesn't seem to matter who it is or where they're from. Nearly all of them have been rude, obnoxious, totally inconsiderate of the neighbors with their noise, with their partying, with the radios. It gets ridiculous. For me, I can't enjoy being outside of my house. They have to say what they intend to do to their significant others. It gets really old. I brought up some specifics back in November. I won't go back through those. But recently, 2 weeks ago, there was a group of young guys there. I kind of jokingly refer to them as frat boys, but sound like young guys. They were out all weekend at night, partying in the hot tub, you know, yelling, again, all the expletives, things they were going to do to each other and to their significant others. Excuse me. At one of the nights at 11 o'clock at night, I'm listening to the news, and all of a sudden I hear voices louder than the television. So I open my kitchen door. They're at it again, enjoying the hot tub. They're out there yelling. I yelled at the top of my lungs 3 times to quiet down. Finally, on the 3rd time, they heard me. Somebody heard me. And I heard them tell the others, hey, some guy just yelled quiet down. I thought, okay, hopefully this is it. One of the group, I heard him say very loud, and excuse my language on this, but he can suck my ass. We should not be putting up with this stuff. The weekend before last, I have a picture on my phone. I wasn't home, but my son sent me a picture. The people who were staying there pulled their car around the backyard. They had an illegal campfire. I say illegal because there was no permit, and I used to enforce those laws. But they had their car facing my house, and I can show you the picture. Their headlights blasting right in my kitchen. No need of that. You know, these are the types of things that I'm putting up with. I know my other neighbors, excuse me, my other neighbors brought up a lot of things back in November, so they have their concerns. Hopefully you have it on record. Would you like to see the photo that I have
I don't,
of the
does
vehicle?
anybody need to see it? I mean, the description. Beg your
We're
pardon.
good.
I believe
His call.
Yeah, you're-
If you want to show it, it's fine.
Okay.
Bob, how long have you lived at your address?
October 95.
Thank you.
Thanks, Bob.
So,
Okay.
so these are concerns I have. And I can't go out and enjoy being by my campfire. I can't go out and enjoy sitting on the deck to read. I'm listening to this constantly. So it's just very upsetting for me as a neighbor, and also seeing it as what I consider to be a violation of our ordinances. Did you guys want to see this?
Bob, can I ask you a question?
Yes.
1,000-gallon septic tank, is that valid for a 5-bedroom house?
1,000 gallons? I don't believe so. I believe it's 1,250 or bigger.
That's what okay. This says 1,000, so that's, okay.
I would have
It
to,
also says roughly 4
Right.
bedrooms, which is correct, yeah.
Well, right here it says 5.
Where does it say 5?
The house is
Oh,
advertised
the
as
5 separate sleeping rooms, yes, but it also says
Yeah, I
septic
know.
tank is 4, yeah, right,
Yeah,
yeah.
okay. Thank you, Bob.
questions?
Do you wish to respond to that? Okay. Anybody else wish to speak?
Mr. Chairman, I have a question.
I need to swear you in then.
Okay.
Okay.
I can't hear what you're saying.
Wow, that's the first. Usually I'm seeing that.
Okay.
Speak up, Bob.
Okay. Do you swear that the testimony you are giving pertaining to this case will be truthful under the penalty of perjury?
Yes, I do.
Okay.
My name is Bill Dempster. I'm here in Madison. I just had a couple of, actually a couple of questions. I've spoken before, so I haven't, the reason they didn't come up and ask to speak was, will I be allowed to say, I have some additional information. I know the board was looking for this information to set up a timeline. I know you had asked about intent from the applicant, and I was able to find that information for the board to help them potentially look to use that information to make a decision. Would I be permitted to provide that information to the board?
Sure. Is this that information?
No, that came from somebody else.
That
Somebody-
was what I presented back in November.
Okay.
So there's nothing on that. I don't think we have to review any of that.
No. Is
I
there something
know you
new?
Excuse me?
There's something new.
There was something new specifically regarding questions you had, Mr. Chairman. And if I can. You had asked about timelines, and from the case of 2310 intent, and you're looking to set up some timelines. There was information I did find and actually contacted the realtor that sold the property. His name is David Hain, very nice man. He declined to present any information here. He didn't want to, I don't want to get
Yeah.
involved. Fine, I didn't get it. But what he did provide was information on the property and some time, which I think is important for this. And I verified that with the Prime MLS, which is used in, used to be the old Nearen. One is it was listed starting April 8th of 2022. A contingent was placed on that, and Mr. Haynes verified that with the current owner of May 5th, 2022, and of course it's verified at 7/8/2022. And that 7/8/2022 was listed as the day it was sold on Carroll County registry of deeds.
Okay.
So I know you were looking for that timeline. I don't know if that's going to help you now. I don't know what direction, but I know you were looking for that information.
Yeah, thank you. They did provide that information too,
Okay.
so.
Thank you.
Okay. Okay, anyone else wish to speak to this case? Then we will collect our findings of fact. I want to do that before we close the public hearing so that you have a chance to correct anything that may be misrepresented, because the findings of fact for the public are the foundation on which we make the decision. Okay, so board members, assist me in collecting findings of fact here. I'll just start speaking, you just can continue. So the date in question is March of 2022 is the date of the change of the ordinance. The sale of the property is July 8th of 2022. Other relevant facts that are particularly critical.
I would say that the owners did provide and testified to the fact that they did not start renting until September of 2022. I believe it's September 30th? Is that?
Yes, that's correct.
And am I correct that we don't have previous from the other owner that he was renting?
I had a question for Mr. Boyd about that, actually.
Go ahead.
Mr. Boyd, did you know the previous owners personally?
Yes.
To your knowledge, did they ever short-term or rent it for a period less than the ordinance specifies?
Not to my knowledge. They did rent the house, but it was long-term rental. And then they moved back in and stayed as permanent residents, I believe, until they sold it.
Okay, thank you.
Okay, so another statement of fact is that neither the owners nor the abutters are aware of it being rented on a short-term basis before. Well, I should ask that. Are you aware? I mean, you didn't make any claim of that, but okay. Okay, other statements of fact?
I'd like to address that the house has a 1,000-gallon septic system.
Just, okay.
And is advertised as a 5 separate sleeping room,
5 bed, 3 bath.
5 bed, 3 bath, accommodation.
Well, in this case, Mr. Boyd, just from your perspective as code enforcement, is that septic tank legal, so to speak, or does it meet code requirements for a 5-bedroom house?
The town doesn't approve the septics, so when I receive a building permit application, say for a new house,
Yeah.
I have to get a copy of the approval from the state's
state.
Department of Environmental Services. So they do all the application reviews, the inspections, and the approvals. The town just gets a copy of it to make sure that it's meeting whatever bedrooms proposed.
So it's state requirement, not town requirement?
Right. There are setback requirements that the town has.
Yeah, the town has, right.
Right.
Yeah.
And do you know what the state requirements are?
For size,
Yeah.
I don't know for sure, but I believe 1250 is what they use for a 4-bedroom. I don't know if that's adequate for 5 or not.
5.
Do we know what year the house
If you
was
don't
built?
mind, I can explain a little bit.
Come to the microphone and restate your name for those listening.
When it comes to a
Restate your name, please.
Nick Burley.
Okay.
When it comes to septics, okay, 1,000-gallon tanks today are very common, whether it's a 2-bedroom or a 3-bedroom. The big thing is the field, okay? I'm sure you're aware of that. So you can't go buy a 1,000-gallon tank and say that it's a 5-bedroom. You have to go exactly by how the leach is.
Yeah.
And that's how it's determined.
Okay.
So
Good to
Do you
know.
have any certifications in that, Mr. Burley?
I don't, but I've been in business for 45 years.
Okay.
I retired, been around it all my life since I was a little kid, and I can give you a little idea.
Okay.
Thank you.
Okay, thank you.
However, I do think it's safe to assume, based on their testimony, Mr. Boyd's and Mr. Borelli's, that if the house was constructed, it had, at the time, an appropriate septic system approval. So I don't know that we can make a big deal of septic tank.
Do we know what year the house was built? It's not on the record.
Do you know what year the house was built?
Tax card, Mitch.
Yeah, that's fine.
Is that relevant to us?
Well, the house was built, say, I'm going to make up a number, I have no idea, say it was built in 1990, and at the time, the septic system was approved for a 4-bedroom house. That septic system is now operating on a 5-bedroom house, advertised as a 5-bedroom, 3-bathroom house. I would suspect that the standard would be somewhat different, and the certification for the septic system would, if you're going to use it as different than it was constructed and approved for, that potentially you would need either reapproval, or they might require upgrades to address a larger accommodation of people in the household. So I believe, I would think, that knowing when the septic system was constructed and the rules that were in place at that time, I don't know. I'm not an expert. I don't know if leach field requirements have changed over the years. If it was constructed in 1970, those leach fields and those septic systems may not be up to code for what we're going to use the house for today. Correct? Yes? No?
Well, that's true. However,
Right, so,
we're looking at this from a zoning perspective, its application to the zoning law, and no one has presented us with facts that indicate that the house is out of spec.
true, and that's why I asked, I just asked the question
facts.
what
No,
year it
you're
might
right,
be.
it's worth asking the question, but this is findings of fact. We don't have a finding of fact regarding the certification of the septic tank.
Okay.
Mr. Borelli has another comment. He had his hand up.
Sure.
Did they, can I ask if, put it this way, since the 80s, we'll say, most septic systems, once you know, if it says it's a 3 or 4 bedroom, that's it. And if you go to add a bedroom, it's mandatory that you have to have an engineer come in and, take a permit, do your perk or so forth and so on, and then redesign the system accordingly and add to it. And they could have had, I don't know if they did this or not, but a lot of times you'll do a septic, when you purchase a home, you'll have the septic checked, and that will give you an answer as well.
Yes, that's true. One thing that is true, though, I know from purchasing a home in New Hampshire, is that if you purchase a home in New Hampshire, you're allowed to operate it at whatever status
Correct.
you purchase it at. So the status of the septic tank, I don't think is relevant to their use of the house. They purchased it in 2022, they bought what they had, and that is,
Was it a 5-bedroom at that time or a 4?
Well, I'm looking at the tax, and I actually did find the year that it was built. It says a 2.75-story frame salt box built in 1990 with 2 bedrooms, 2.5 baths.
Well, guess what? 2 bathrooms, 2.5 baths. That's what you're supposed to go by. Not 5.
right. Well, and...
I'm not trying to, I'm just.
No,
trying to
I
help.
understand.
Please
No,
understand.
I understand.
Okay.
The point is that when the house was built, it was built as a 2-bedroom house.
Correct.
Did you add a bedroom to did you buy it as a 5-bedroom?
Technically, we didn't add a bedroom, because there's no closet in it. but
Yeah.
There is a bed in a room.
Yeah. Okay.
It was sold as a 3-group,
I beg your pardon?
sold to us as
A 3-bedroom.
I was going to say, they can't hear you, so if you could either speak louder if you're not going to come to the microphone, so that the videographer can register. Yeah.
Okay.
Would you repeat it for me, please?
Yeah.
Yeah, if you don't think that you can be heard loud
I'll just
enough.
restate it, you can hear me. It was sold as a 3-bedroom
Bedroom.
house, is what my client said.
Okay.
Everybody, did you hear
Sold
that?
as a 3-bedroom. It's operating as a 5.
Okay, so statement of fact is that the house was built in 1990 as a 2-bedroom house. It was sold as a 3-bedroom house. We don't have any record of any adjustments to the septic tank, whether it was done or not. As it's being advertised as a house with 5 sleeping rooms in it. Those are statements of fact. Is there anything else we want to add as a statement of fact?
When they purchased it, which was after
ordinance.
why we're here tonight, were they not notified that they could not use it as a rental? In other words, we just, a month or 2 earlier, 3 months earlier, had passed that ordinance. And I wonder,
How would, just out of curiosity, how would they be notified of that?
well, they have to deal with the town in some way, shape, or manner, I would think. No? I'm just asking because, you had no understanding of the warrant article, so. That's why we're here.
Say something.
Yes, sorry.
If I could just comment on that real quick. It is the buyer's responsibility to check the town's rules and regulations before they commit to purchasing a property in a particular town. I'm constantly reminding people of that. I'm constantly being asked questions by people considering buying a piece of property in town. And I always tell them, make sure you look through the zoning ordinances, look through all the ordinances and rules and regulations in any town that you may move to, just to make sure that's a place that you want to go, or a place that you want to own property. So to me, it's the responsibility of the buyers or potential buyers to research that before they make that purchase. It's not the town's responsibility to notify them before they make that purchase. On the septic part, as I issue building permits, I have to make sure when I get a building permit application, if the number of bedrooms in the house is increasing, I have to make sure that they've either have an adequate septic system rated for the number of bedrooms that they'll end up with, or that they either get an approval from the state for an upgrade, if they choose to do that, or a letter from a licensed septic designer that's assessed the system and says that the current system is adequate for the additional bedrooms. So those are the things we need to see at the town level before a building permit's issued, if bedrooms are increasing. And I don't recall if there was ever a building permit for bedrooms increasing or not, from 3 to 5. And I asked the question of our assessor one time about the bedrooms. Is it a bedroom whether or not it has a closet? Does it have to have a closet to be a bedroom? He said no. If it's used, do you have a room that's used as a bedroom? It's a bedroom, closet or not.
I have a question for Attorney Bolt, then while we're still in the. In their sworn statement, they made reference to the police chief and receiving a letter and receiving noise complaints. As a member of the police department, can I speak on that? Because I have no vested interest in the outcome of it.
Let me ask this question. You're not the chief.
I am not.
You didn't send the letter.
But we also have a giant stack of police calls that we received a public information request for, and my name will appear on some of those.
Right now, we haven't. I'm not sure it's a material fact that you're needing to get into concerning the timing of things, since this sounds like a straight timing post ordinance versus a grandfather case. So
I just, there was reference, so I won't.
concerned on if we get into an irrelevant fact, then is this a matter that you are then a witness versus a board member?
Okay.
So, and if there's any concern on your part, Matt, you can get into it if you wish, have him recuse himself, and you go forward on a 5-member board on this case, a 4-member board. I'm not seeing the police reports in this matter is really the driving factor.
I didn't even know they existed.
I
until-
didn't-
I mean, I guess I haven't heard any testimony about it. I haven't seen anything about it. I don't think it should be a finding of fact because there's been no testimony about it one way or the other. And I'm not sure it's a relevant issue to.
No,
Right.
I just wanted it to be out in the open.
No,
I appreciate that.
you ask it.
I appreciate that. Somebody had asked for the police reports in there, but based on what I've heard in the findings of fact that you have discussed so far, I think that one is, forget about left field, you're in the next stadium.
Okay, yeah.
So you have what you have here, and I think it would be cleaner to keep you in that seat.
Okay.
Well,
I
and
agree.
if I might speak as chairman, I also would just like to say, from my perspective, the discussion tonight is whether or not this is consistent with the ordinance. The fact that someone complained is a collateral information that actually doesn't bear on the question which we're addressing. I mean, it's interesting to know that it's been a problem for the community because it contributes to the culture, but it doesn't answer the question whether or not what their activity is consistent with our ordinance.
You did have some testimony about swearing and the headlights and the things of that nature. I didn't get the impression that those were police calls, but is one where your findings of fact that you've discussed so far are those things that you're finding are after the ordinance date of the March town meeting in '22. Does that
Yes.
help?
Yes, thank you.
Okay, so do we want to include as a point of fact that there were some complaints testified to?
In their letter, it says.
All right, we've just mentioned that there were some.
I would take out the word some and just say that there were complaints.
Okay, there were complaints. Okay,
This, some sort of tries to quantify it.
right, no, you're. Okay, so I have 8 points in the finding of fact at this point for the board. Let me just make sure they make sense and order well. Okay, so March 2022 is the date of the ordinance. July 2022 was the date of the purchase of the house. Date of the first rental is September 2022. Mr. Boyd, as well as the owners, have testified that none of them are aware that the house had been used for short-term rental prior to that time frame. There was a discussion of the septic tank, which is likely not exactly according to today's standards, 1,000-gallon tank, it having been built as a 2-bedroom house, sold as a 3-bedroom house, and being used as a 5-bedroom house. There's no record that the buyers, excuse me, that's not, let's leave that one out because I got half a sentence there that I didn't finish. The next one is that there were complaints regarding noise. What I was trying to say with the previous one is that the buyers were not aware of the terms of the ordinance. Any other points?
No, that's how it
All right, unless anyone,
Mr. Chairman, may I ask
yes,
questions? Step up here.
restate your name.
Yes, thank you. Bill Dempster again. Just wanted to bring forward a couple of facts that for you to consider as facts in the case. One is that no one in the town spoke in favor of this administrative appeal, with one. And secondly, and in my opinion, there should be something in there regarding the procedure and process by which the town followed, and they followed it directly as in accordance with the Madison zoning ordinance, so there was no deviations. It followed right to the letter of the law.
Okay, I'm not sure I want to include the first one, was a
That's fine.
statement of nothing that is, you know.
You could say the people appealing spoke in favor of it, but
I just, if I may, reading in prior cases that there were facts of finding that residents spoke for it and residents spoke against it, something in that line.
Yeah.
That's up to you if you'd like to put that
Okay.
in.
Thank you.
Okay, thank you.
Yes, Mr. Boyd.
I just wanted to clarify my comment about the previous owners and living there. The Fratties, I believe, lived there full-time, pretty close to 2 years or more prior to selling to the Maderos. And prior to them moving into their house to live full-time, they rented it long-term for, I believe, at least a year or two before that.
Okay.
So, just to clarify,
It was rented long-term is what you're saying?
but from 2020 to 2022 roughly, they lived there full-time?
I believe so. I don't know the exact dates, but it seemed like at least 2 years.
More than a
Okay,
year.
yeah.
Accurate.
So, point is that that would provide for a lapse of the, yeah, okay. Okay, any other questions from the board? If not, then can we move to close the
So moved.
Seconded.
Okay, all in favor?
Aye.
Aye, okay. So for the public that may not be familiar with the procedures, we are now proceeding with the deliberation. This is a public meeting. You're welcome to listen in, but there's no further contribution from the public, okay? Now, what I'm going to suggest to the board is that I provide you with a statement of argument. What I'm doing now is giving you a procedure. So what I want to do is read off the procedure. I'm going to make a statement that I think lists our arguments. Then I want you to consider the testimony of the agent, Mr. Johnson. Then consider any testimony that's been provided by the community. And then based on our findings of fact, as the last step, we will make a statement of, our argument and move to either grant or deny the petition. So I just wanted to provide some structure for our thing. So what I'd like to do actually is give you an idea. So first thing in our argument is that RSA 674-16 grants the town's legislative body, which is the town meeting, the authority to regulate the usage of buildings and property. Transient rental was permitted probably prior to March 2022, and that's supported by the fact that the practice was widely, short-term rentals were widely used in Madison without being legally contested. And the New Hampshire Supreme Court, Conway versus Kudrick, basically supported the idea that short-term rentals are residential use. And the significance of that is that our provisions in 4.2A and 4.6A, which give the permitted uses for the residential areas in Madison, do not restrict short-term rentals. However, the court case Working Stiff Partners versus the City of Portsmouth concluded that the specific wording of the ordinance makes a difference. In particular, they were referring to transient rentals, and our ordinance specifies transient rental. So the point is that their argument turned on the clarity of the wordings, which prohibited a very specific action, in this case, short-term rentals, transient rentals, and our ordinance addresses the question of transient rentals as well. So what our ordinance actually says specifically is that permission is granted in Article 4.2A and 4.6A for residential use in those areas, Edelweiss and in the rural residential district. But our ordinance specifically defines transient use as rentals of 30 days or less, and it specifically prohibits the use of transient rentals in terms of what a dwelling unit is, the definition of a dwelling unit. So the town of Madison contends that though some consider rental of a dwelling unit for any period of residential use, the rental for transient periods of 30 days or less is prohibited by our our zoning ordinance. So basically, that is the rough position that we take, is that the ordinance, as it's specified in March 2022, defined transient rentals as 30 days or less, and prohibits the transient rental of dwelling units in Madison. So we can come back and adjust that statement at the end, and but that's a starting off point, okay? So now, we had Mr. Johnson presented 4 arguments for the fact that that ordinance is not valid. I think we could perhaps go through those points. Yes.
May I suggest a point of order, Mr. Chairman? You've made your statement.
Yes.
And I think it would be a little cleaner to see if there are any disagreements, any agreements, anybody wants to tweak that language, because that's yours, and then you know if it's the board's.
Okay, good point. And then we'll continue on with this discussion. So, clarifications, questions, disagreements, additions, subtractions.
I do.
Sharon?
In reading your statement, I'm sorry if I can take a look at it, though, too. You mentioned the idea that prior to the March 2022, that this was, you know what, I don't think we should, this case deals with homes that are being rented as a short-term rental post-March 2022.
That's what this case is about.
Correct, and I think that's where we should stay. I do not believe that at this point in time, this board has a need to try to go through the 87 to 22 ordinances and figure out where the town stands on that and what, I mean, I believe
Okay,
we're
no,
still
that's-
seeking legal advice on those, on that piece.
Well, at least the point is relevant to this case. What's important to establish is that the ordinance was established in 2022.
Correct, yes. That there was an ordinance established in, a clarification of an ordinance established in March of 2022.
Okay,
Okay?
all right.
Does that make sense?
Yes, that makes sense?
Anyone else?
Oh, that's good.
Okay, so the essence of what that argument was is basically that the town's, the legislative body, has the authority to regulate building and land usage. Point one. Point two is that even though residential use, short-term rentals was recognized as a residential use by Conway versus Kudrick, the Portsmouth case indicated that specific language defining particular situations will obviously not obviously, but overrides that. So the point in particular in that case was also transient usage of a rental. And our ordinance, so third point is that our ordinance specifically prohibits the transient rental of dwelling units. Okay, that's basically it. Okay, now, I'm putting it down there now. You can disagree with that as a board, and we can go the other direction. It's just as a starting off point. Okay, so now, let's go and look at Mr. Johnson's 4 points and decide whether those 4 points override those 3 points. Mr. Johnson's first point basically, figure that out. His first point is basically that the amended term dwelling unit is overly vague, not specific, and basically isn't adequate to specify what we intended. We can take the position that actually we agree with him or we disagree with him. I think he's presented that case.
I would disagree with him. A dwelling unit is exactly what it is, a place to dwell. And I would say that the ordinance deals with a dwelling unit because that's what you do at a hotel, at a short-term rental, bed and breakfast. You sleep there, you eat there, you bathe there. I think dwelling unit is the proper term.
Okay. Other comments? One of his other comments is that one of the reasons why he considered it vague was because it doesn't specify rental. One could argue that it would be inappropriate, well, the context argues for the fact that it is rental because the ordinance clearly is not restricting an owner from using his own home for 2 days. That seems fairly easy to draw from the argument here that the context is rentals. The question here is whether this is so vague that it doesn't make sense or whether that's obvious.
If that's vague, then state law pertaining to motor vehicle law is vague because a rental car is the same as a personally owned vehicle. It's a car is a car, a house is a house, is my argument.
It's a good analogy.
Comments? Doug?
No, excuse me, I'm fine.
Okay. Alrighty. Well, okay. I mean, my argument would be that this is our statement of the definition of dwelling unit is clear enough that the restriction applies clearly to rental because it's inherently obvious from the context of the ordinance that we're not restricting an owner's use of the house for a weekend. So I would say that this is not overly vague. Transient and non-transient is quite clear. What a dwelling unit is quite clear. Any agreement, disagreement?
Agree.
Agree.
I agree.
Yeah, I agree.
Okay, so the second point, which he mentions, is the amended Madison zoning ordinance violates substantive due process rights of the Madeiros and creates a regulatory taking under New Hampshire and federal constitution. And I would say the simple answer for that is that RSA 674-16 grants the town's legislative body the authority to regulate the use of land and buildings, and I don't think there's anything else to say. You agree, Sharon, Doug?
I agree.
Yes, yes.
Yeah, I agree.
Agree.
Okay. Third point is the amended Madison zoning ordinance violates the Madeiros equal protection rights. Amended zoning ordinance affects property so that it is subject to intermediate level scrutiny. I'm not sure what that is, but Madison cannot show that the amended ordinance is substantially related to an important governmental objective. At that point, I would disagree because the Madison's master plan clearly indicates that we're trying to establish a rural residential community. The situation that arose with Airbnb predates the considerations of the dates of the master plan, so that we can't expect that specific wording to appear there. However, it is clear that if significant numbers of properties are replaced by short-term rentals, shifting them into hotels in areas that were intended to be residences, that the effect of that is on other infrastructure in the town, such as education, because, you know, if houses are now short-term rentals, families aren't living there, the number of kids goes down, et cetera. So I would argue that the town's concern over a large number of short-term rentals does affect our governmental objectives. What were you gonna argue?
Could you also, I agree with you, but could you also argue that the legislative body put the ordinance and tasked the town with the objective of enforcing these ordinances? That's,
Yes, that would be another argument against that, that's right. Okay, then the fourth point was that the amended Madison zoning ordinance violates the holding in Britain versus the town of Chester in that the Supreme Court struck a zoning ordinance that acted to restrict access to affordable housing in Chester. In this case, the Madison zoning ordinance definition of a dwelling unit precludes the creation of affordable housing because the definition is applicable throughout all districts in Madison, and the owner-occupied requirement, as interpreted by the code enforcement officer, undercuts the ability to create meaningful affordable housing. So, comments?
does that relate, is that saying it relate to point one?
Yes, to a certain degree, although it's
Slightly different.
slightly different. Comments?
If somebody's building a house with the intention of renting it short term, I think that undercuts the ability to get some affordable housing as well.
I believe this fourth point is a reach. Undercutting the ability to create meaningful affordable housing, I would think town after town after town across the country would tell you that as short-term rentals become more prevalent, then affordable housing goes away, goes down. It does not get necessarily increased because you have a different element and a different, it's not a residential area anymore. It becomes more of a area for strictly tourism, becomes more like a hotel area, becomes more like a very transient nature, and that drives, it's based more, the demand for that area is much more cyclical and much more what am I looking for? The word I'm looking for is it's much more dependent on what's going on in the economy, whereas being able to afford a home long-term, whether it be a second vacation home or you intend to move into it long-term and raise your family there, is counter to this short-term rental.
Yeah, I personally fail to see the direct relevance of, this to that issue for those reasons.
Yeah, it's hard to see how we went from a situation where we're talking about a home that was rented post March 2022 for rental rules to affordable housing. Seems to me like 4 or 5 hops to get there, and to me it doesn't sound relevant.
Okay, do we need to change any of the points of the line of argument that I had as a result of analyzing these particular points?
Can you state them again? I'm sorry.
The points that I made?
Yes.
Well, that 674-16 grants the town the right to regulate the use of buildings and property. Even though the provisions of the court case Conway versus Kudrick supports the idea that short-term rentals are residential usage, yet the other court case specifically allows the clear wording of the ordinance to regulate specific items. In this case, theirs was very similar to ours. They were regulating transient rentals, and that's what's specifically prohibited by ours. So that's basically our line of argument. Do we need to change that at all as a result of?
No.
Okay, Then let's consider the arguments that have been presented. There were a few things presented by the abutting neighbors. We didn't read a lot of that stuff, but basically, a lot of the arguments related to infractions of, shall we say, what was it, behavior and, public order. And those things are certainly annoying. And are one of the reasons why the town probably enacted the ordinance to restrict short-term rentals. But those things don't bear directly on the question as to whether or not the rental of the property on a short-term basis is legal or not.
That's correct. And I think that's the
Okay.
one point we need to stay with.
Right. Okay. So, okay. Other testimony from people supported the timeline. So in this case, the timeline is not in question. There's no question about the fact on any side that the rental property was not used as a short-term rental at any time, at least within 24 months of the sale. There were a number of other items that were presented to us. I'm just looking to see if anything else is a substantially different. Give me a minute while I just look at okay. Okay, there's quite a bit of detail listed here, however, the basic, yes, essence of it still is that the ordinance is sound as it is. Okay, any other comments? Then whoops, let me get my piece of paper again. Okay, then. Okay, so then let's go ahead. Can we work on a motion? Move to deny or?
Yes.
Okay, move. Well, we'll just get words on a page and then we'll, before we vote. Move to deny.
Case 23-12.
Yeah, the applicants, yeah.
Based upon age statements above.
because there's,
well, the key fact is the rentals began after,
Inception of the ordinance.
the March 2022.
began after March 2022. And because the town's ordinance clearly specifies that transient rental of dwelling unit for 30 days or less is prohibited. That's the simplest statement. A date and the statement of the ordinance. Do we want to add anything else to that?
Keep it simple.
Do you want to comment on that?
You've made 8 findings of fact.
Right.
You can say, based on the findings of fact previously found,
That's what I said.
we do a motion to deny, and that way you incorporate all 8.
Okay. So move to deny the the appeal.
I think we put, based on the findings of fact, we move to deny.
Oh, okay, you
It
want to
comes
put it
first.
based on the findings of fact. Findings of fact. We move to deny
Because
the appeal because
Your because is already in your findings of
Findings of fact, yeah, you don't have to go any
If
further.
you either have, you
Oh.
did that first.
they did that first, okay, so that's sufficient.
refer to those. If you hadn't done those first,
Okay,
we move to approve or deny because, and then you're making your findings of fact. You just,
flip-flopped it.
that's fine. So we've got findings of fact. We said we move to deny because of those findings of fact or based on them. Then it's clear what those are. They'll be included in the decision letter.
correct.
Okay. Further comments from the board? Adjustments? Changes? Okay. All right. Can we vote?
Do we need to have a second to the
We need-
motion?
Oh, yeah.
Second.
So- Oh, yeah, I'm sorry. Let's formally,
You made the motion, Drew, and Doug
I
seconded.
made the move.
Yep.
Motion and Doug
Doug
seconded.
seconds.
Yep.
Okay. All in favor?
Aye.
Aye.
Okay, so that motion passes to deny the appeal. Okay.
30 days.
Yes, I need to read the, if anyone wishes to appeal, one must act within 30 days of the date of this notice, day 1 being tomorrow. The necessary first step before an appeal may be taken to a higher court is to apply to the Board of Adjustment for a rehearing. The motion for rehearing must set forth the grounds on which you base your appeal. Board members are advised to refrain from discussion of the appeal with other board members and any party to the appeal until all periods have expired. Okay, thank you. I will make one other comment, that is that since this is an appeal of an administrative decision, the board will, because we can't predict the outcome of individual cases, but we'll have to act consistently with this in other cases. All cases, however, will be affected by the findings of fact in those cases, so you can't conclude what the outcome of another case may be based on this. Okay. Okay, so that concludes case 2312. We will go on to 2313, which is actually significantly different because there is a appeal based on pre-existing non-conforming use.
Let me know when you guys are ready.
Yeah, 1 second, I got to change all these first. Yeah,
The shuffle.
you understand completely.
You guys have a desk. I have like 4 chairs.
One thing's for certain, the trees hate us right now, that's for sure.
Yeah, well, the legal practice has not been good with paper management. I'll say I am not good with paper management.
Gonna say,
Oh, damn, this is my profession.
I don't know that anyone is.
but you guys are, you in particular are responsible for most of this paper.
Yeah. Guilty as charged.
Okay, so now, we have already opened case 2313 previously, so we have established the fact that it was noticed properly, that there's no conflict of interest on the existing board, although I need to check. Sharon, do you have any conflict of interest with this case?
I do not.
No. There's no waiver requests here, there's no regional impact, so we can go directly to the presentation by Mr. Johnson.
Right, and I think we, my memory serves, we touched on it a little bit before, but I'd like to, what I wanted to hand out to the board was I tried to distill as much as possible with various applicants some of the key questions the board had last time. There were some questions regarding the use of the property both before my clients purchased it and after my clients purchased it.
Okay, there's quite a bit here, so you want to just give us the 50,000-foot view, and then we'll ask you
Absolutely.
questions, yeah.
Absolutely. That was the intent. So I just,
Do you want to,
we put a package together that identifies when it was bought. It also, the key, I think for purposes of what the ZBA is looking for, is there is data that you had before from Select Real Estate, which shows the historical rentals of the property predating the change in the ordinance in March of 2022, but also the details on the rental history post my client's purchase of the property to show that it has been consistently used as rental property so that there's no issue of abandonment under the grandfathering analysis. There, we did address the issue of whether they were ever aware of any complaints, because I know that had been addressed before, the cops had not been called. Again, we provided for the rental history before they bought it in June of 2022 and after they bought it, and also confirmed under oath that my client does pay rooms and meals tax through the Airbnb platform. And so, and then the middle part of this package is the point we made earlier, which is if you looked on the website for information relative to short-term rentals, website at least suggests that there's nothing precluding short-term rentals in the town of Madison, and so that is a challenge when parties are doing due diligence, at least if they're looking at the town website. Not making any comment relative to the zoning ordinance, we made those arguments already, but that's in the middle there, and some of the statutory sites, and then we have a PowerPoint my client put together relative to the rental of the property under their ownership as well, to show that it's been consistent both pre-ordinance change and post-ordinance change, and I'm happy to let you take a look at that and answer any questions. My client's here to...
Your client did that?
I would not have been able to do it.
I have OCD. We'll bring Bill back. Drew,
What's it?
do you want to bring Bill back now?
Bill.
bookings?
Back, because
Yeah, no, I'm going to give us a chance to look at this for a second.
It started in
Okay, so
2017.
the core essence of the argument here, if I might just summarize one primary statement, is that
20.
this house has been consistently used as a short-term rental for
And then
50 to 90 days a year since at least 2017, and there has been no lapse. That's your core argument?
Yes.
Okay.
And for my notes, Mr. Chairman, there was a cough. You said a number that he agreed to. What was that number?
Oh, 60 to 90 days a year approximately.
I have to look at the dates, but I haven't run the calculations, but it's
Yeah.
extensive, consistent from 2017 through the present.
Yeah, so actually, yeah, so the low was 41, the high was 78, but just, we're not trying to be highly precise here, but we're trying to give a ballpark estimate, 50 to 90 days, round figures. Okay, Before we get to comments from the public, are there any questions from the board for Mr. Johnson or? Okay. How many people wish to speak to this particular case? Okay, can I have everyone who wishes to speak to this case rise and I'll swear you in? Do you want to? Okay. Do you swear that the testimony that you give pertaining to this case will be truthful under the penalty of perjury? I do. Okay. All righty. Who would like to speak? Anyone?
Who wants to go first?
Who wants to go first?
Someone?
Bueller?
That's why they were sworn in. They were sworn in to speak.
Nick Borelli, Madison. I want to bring one thing forward that I don't know if the town's aware, but when it comes to an ordinance that's existing and the town does not enforce it, doesn't mean it's gone away. All it is that if something's been brought to the attention to the town, from that point on, it has to follow the ordinance. No different, like we'll say if Mr. Boyd, all right, someone's doing an addition. He hasn't pulled a permit, this person, and no one says anything. Mr. Boyd doesn't go looking for things like this. But if someone was to come along and say that that particular property, I have a problem with that because I don't believe they have a building permit. If the gentleman finds, he doesn't and he brings it to Bob Boyd's attention, at that point, Bob Boyd has all the right in the world to put a C&D letter on the property. That's no different than the existing ordinances that have been here since 1987. And anytime something came up with, especially the short-term rental stuff or the rentals, it was always strengthened year after year after year. Anytime there was an ordinance, the intent, we went back to intent from the very beginning. You went back to try to help the gentleman as much as possible. So once you've opened up Pandora's box, you have to go back. Now, the STR owners have already tried to go back, and they have. Now, their representative has gone back a little bit. Well, we have information that goes back further, that's contrary to that. We have the proof. So I'm just trying to get a point across that that's how it is now.
Well, okay, so
In my opinion.
before you sit down, what I'm hearing you argue is that since 1987, short-term rentals have been illegal.
I'm saying, okay, that there's ordinances in place in certain districts, starting from then, that were in place. Once you go to the original part of when the land use, all the zoning and everything went into place,
Right.
It started then. And there were, each year that came out, there was different ordinances that were strengthened. And it did go all the way back to there. I'm not,
Well, okay, if you're maintaining that a short-term rental was not permitted, can you give me the article and the paragraph that does not permit that?
well, there's things in there that explain, okay? Back in, we'll say, for instance, in 1967, okay, in order to rent a home, you had to have room and meals tax number, so forth and so on.
Yeah.
Just like you do today, okay? Now, I don't have the ordinances in front of me to be, but for instance, I'm saying you have to look back, okay? So if a garage was allowed in one spot, and then it was, once that ordinance, I think it's 3.1 or something like that, explains that, once that's been abandoned, we've already gone through a little of this, once that's abandoned for 1 year or more, it's not allowed anymore. What I'm saying is that whether it's all the way back to 87 or all the way to now, its burden of proof is up to them to show, but we will keep bringing stuff forward that will be going back, just like they are.
Okay, let me, what the board would need, the board is currently going off an assumption, not an assumption, off the reading of the ordinance. It says prior to 1987, there was no ordinance. In 1987, there was an ordinance, however, residential usage and short-term rentals were not distinguished,
Correct.
either in our ordinance nor in practice. And occasional court case, most recently Conway versus Kudrick, the residential usage and the short-term rentals were allowed, and there was no distinction. So the bottom line is, we draw the distinction at March 2022 when the language in our ordinance specifically defined transient.
No problem. I understand.
I'm just simply saying that, so we have 3 periods of time, before 1987, between 1987 and March 22, and after March 22.
That's what I'm saying, and it always gets stronger. And the burden of proof is up to them, and now they're saying that they have information that's going back to, what was it?
Well, this one's back to 2017.
Okay, well, we have information that goes further back than that.
What information are you?
Well, that it wasn't rented, okay? The lady can come up and read it.
Well, but it's not relevant to us as long as it was before 2022 and
Why
didn't.
would you give them the right to do that? And go back to, I'm not trying to be nasty.
Well, I'm actually trying to understand your line of
What I'm
argument.
trying to say is, we have to take each individual case,
That's right.
okay? And as it comes, we may end up going back to earlier times when there were ordinances put in place back in like 1990, 2011, so forth and so on.
Okay.
Okay?
Can I?
Go ahead.
Can I try to summarize this? I think correct me if I'm wrong, what you're trying to say is that historically, so the house was built in 1984. There's currently, in front of us, no evidence to indicate that that house was rented, short-term or otherwise, from 1984 until 2017. In 2017, there has been evidence presented by the applicant that the house was rented approximately 60 times a year. Is that what we're
Yeah,
averaging?
60 days.
that's fine. Yeah, and
Yeah,
that's close
60,
enough.
60 days a year. And that evidence, and they continued to rent post-2022. What you're asking is, based on the lack of evidence prior to the 2017 information, that we consider that information, and we consider the fact that historically this home was not a short-term rental, but only in the history of the house, more recently was it.
Correct. That's what I'm trying to say. And, because we end up having to go back. So if you go back if you allow that, you have to allow us to be able to go back. That's all I'm saying.
Okay.
Okay? I mean, that's how it is. Common sense, common man law.
Mr. Chairman, may I ask a question?
Yes.
Just because Mr. Borelli, I'm trying to understand your argument.
I'm sorry, I'm all over the place.
No,
And you can say it.
but
Sorry.
it's okay. Is it your argument, to build off Sharon, that if there is any window of time after 87 that it wasn't rented, but there is a window of time, as in this case, from 2017 to present, that it is rented, that somehow controls? Is that what you're saying?
I don't know if you're getting that. What I'm
Okay.
trying to say is, let me explain
Gesundheit.
the best I can, okay? Sharon has hit the nail on the head more than better than what I was trying to say. In other words, all right, since 1987, and these
I
ordinances have
understand
been
now.
put in place. Every year they get stronger, or every other year they get stronger. Okay?
Okay, can I stop you right there? Ordinances change all over the world,
Correct.
all over the time in this town, year by year. But the fact that there is a zoning amendment on other passages, other provisions of the ordinance are irrelevant to this issue, which is really limited to the clarification that occurred in March of 2022.
Correct.
Okay, so is your position that there was a zoning amendment that is relevant to dwelling unit, short-term rental issue at some period of time between 1987, when the original ordinance is put in place, and the 2022 amendment that we're dealing with?
Absolutely.
Which ones would you tell us
Okay,
of?
4.6 right off the bat.
4.6, what year?
That would be-
4.6 is the creation of Edelweiss District?
Actually started in, it actually started in 1990. That's when Edelweiss was put together,
Okay.
okay? Edelweiss is way stronger. Our language is so much similar to Portsmouth case, and everybody understands that.
You need somebody to carry that for you.
Yeah,
And it
section,
says no commercial is my recollection,
well,
correct?
Business, commercial.
okay, and when we
Regular
talk about no
business.
commercial, the representative from the group of the AR owners actually says that they're in competition with motels, hotels, and those
I
industries.
hear your argument, and I'm not meaning to take over, but I'm trying to.
I'm just trying to give
but
you where I'm
I want to
coming from.
hear what you're saying, but have you read the Conway case?
I have, and you know
Okay.
what? We're even stronger than Portsmouth.
No, I'm saying Conway case. The Conway
Okay,
case that,
yes, I have.
okay.
But that just, and it goes to the language. Okay? Everything comes to the language, period.
Correct.
Okay? We
But-
also have stronger ordinances here than Conway, generally speaking.
And you're looking at paragraph 4.6.
I'm looking at 4.6 in one area, correct.
Okay.
Okay.
Is there any other passage that we need to focus on for the board?
Well, there'll be some other things that I'm not prepared for. I apologize.
Tonight's the night.
Okay, well, all right.
I'm trying to
I'll tell you
understand.
what. John, can I please bring John up here?
Sure.
Okay.
He's sworn into.
Yeah, you know what I mean?
Yep. State your name and,
Sure, John Kancelarich from Melrose, Massachusetts. Can I give you guys my speech before I start it? My pieces of document? Can I approach?
well, yes, but give us the 50,000-foot view of this first.
Okay, I'll start that first. Okay, thank you for letting me speak. What I did is I used the Supreme Court ruling with the working stiffs to illustrate the similarities to our Melrose case. And the Madison ordinance I used because I found online the 2018 one, but a lot of these terms go backwards. There's a 2012, there's a 1990, there's 1987. Specifically looking at Edelweiss, where this district is, the key points established are Madison's ordinance established a permissive zoning intended to prohibit uses that are not expressly permitted.
Right.
2, when a definition is defined, it must be used, and if it's mentioned, then we can use common language. The important definitions are motel, a building or series of buildings in which lodging is offered for compensation. Number 2, commercial use, any use involving in part or in whole the sale of merchandise, materials, or services. Number 3, business is mentioned, not defined. So I do exactly what the Supreme Court did, is I use Webster's Third New International Dictionary, defines business as dealing or transactions, especially of economic nature. The SGR, they argue that the proper usage is short-term rentals. It remains a dwelling unit where it's mentioned once, residential, it says what? Residential purpose. It's only mentioned twice in our ordinance. Residential purpose there, and it's also mentioned under Idlewice for a dwelling unit. Residential purpose cannot be used for residential purpose. Okay? So, if you look at the structure,
Repeat that last statement.
there's only 2 spots in your ordinance where it says residential purpose.
Yeah.
Number 1 is in the Idlewice one, dwelling unit. It's under defined for dwelling unit. The second one is under accessory dwelling or accessory unit, where it says that you cannot use for residential purpose for Idlewice people. So, if you look at this definition, they're saying it's a dwelling unit, that it's residential purpose. But as a structure, it's a house. Yeah, it's a dwelling, it's a house. It has the structure, but in principle, its use fits more of the mold of motel, commercial, and business use. Its true form, STRs, are buildings in which lodging is offered for compensation for economic transactions. The client pays for the service of easy booking and staying at the STR, and the client finally pays for the service of cleaning the STRs. Services, compensation. Strictly in 4.6, it states businesses and commercial use is not allowed. And it's been on the past, too.
Okay, I hear what you're arguing. What you're arguing effectively is the minority opinion of the justice in Conway versus Kudrick. And the majority opinion is what we have to follow. And the majority opinion is that residential usage in short-term rentals were meshed together. That short-term rental is not business use.
But you have to use our definition. If we're saying you can do commercial use, and we say you cannot use businesses in our district, you have to use our definition, not their definition. That's where your confusion is happening. It defines exactly what it means, and that fits the mold of what STRs are in our district. So what's happening is he's cherry-picking residential purpose and not using the full definition of 4.6. That's what's happening here. Also says one should not construe the Madison zoning ordinance to lead to absurd results. He's mentioned second-term home users can't stay at their place for 30 days. Can I just get a drink of water real quick?
Of course.
It's right there.
Sorry. Just glad to do it.
So it says in that case, the Portsmouth case and the Supreme Court, he's making absurd argument to confuse you. So 30 days or long-term residents can't become resident, isn't allowed long-term renting. I also want to emphasize that because the ordinance is not unconstitutionally vague, merely because it's not drafted with greater precision or the wording doesn't precisely match one of the standards you're looking for. They say that exactly. The Supreme Court also states the ZBA needs to find a reasonably based judgment here. It's reasonably based. So if you look at it, you're like, residential use, there's no separation. There is by 4.6. You look at it, an STR is a business based on common use. It is commercial use based on our definition, and it fits what a motel is. And that's not allowed in our district. And this dates back, okay? So in conclusion, it's reasonable for you to determine that short-term rental use is similar in use in mold to motels, commercial use in businesses, and therefore prohibited in the Idlewice residential district. Number two, if you read the Conway case, they said this is specific to Conway. You really, they do say that. It's specific to Conway. You're trying to generalize it here. You need to use the words in the ordinance in order to effectively understand what people want here. Okay. And lastly, I heard comments from the last one. Section 2.1E, the last sentence of Section 2.1E says, failure by the selectmen to not initiate enforcement under the ordinance will not constitute a waiver of the town's right to take such action. There is no backlog. You cannot say because we let it go, we can't ban them now. That past existence, we even stated here, 2.1 in our ordinance, that covers us for that, which says, once again, failure by the selectmen to not initiate enforcement under the ordinance will not constitute a waiver of the town's right to take such action. And any questions on this?
No? You have that on one sheet of paper?
I do. And I have, what I've done is I also taken the worker stiff, and I put our terms in it. I left the full Supreme Court's ruling, and I put our Madison zoning on it so you can see how identical it is and how they went through the process.
I object to that. That's just taking a court case and adding different.
Am I still speaking, or should I be interrupted?
You're speaking, well, you can rebuttal, give him a rebuttal.
No, I want to object to the admission of that document. He's saying he's taking a Supreme Court case and adding different terms to it. I don't think that's appropriate for an exhibit.
What I've done is, if I can generalize.
One moment. Sure.
Unfortunately, the answer is it depends. And if it is a simple page that is clearly, you're taking a passage, you're adding some language, it's not being represented as this is a copy of the opinion, starting with the first and going to the last, and we're changing language like that.
What I did is I put ours in boxes, so it's completely separate.
For comparison purposes?
For comparison purposes.
Okay, thank you.
You can give a copy
Give to him,
to Attorney Johnson, please. And then you can give it the weight it deserves. It's a lovely phrase. The courts tell us all the time.
It's the exact court case, just changed words. I have a problem with changing a Supreme Court case.
I hear what you're saying.
Just so you're clear, I have no problem with if he has a summary of his argument that he wants to give to ZBA, perfectly fine. I have no issue with that. That's normal. But this is a court case that is now changed, and it looks like a court case, so I'm just a little fearful, like, some down
Can
the
I
road,
actually
people are
see
going to
it?
say, what is this?
Right. I think if it's marked clearly as a created document.
So I don't have a problem with
Okay,
it.
the first page clearly says, and it says
If you read up top what I
he's
did.
done. Attach in its entirety, I've highlighted in bold the pertinent information and inserted text boxes. So he's not,
Altering the flow of the
You
opinion.
can't take a Supreme Court case about something and then put new facts. It's a Supreme Court case. He can make an argument, which he did.
I separated by boxes.
put it this way, I think what he's done is clearly,
I don't agree with that.
you
know,
can
do-
make
board
the
can do what
objections
you
on the
want, but that-
record, you've heard him, it is what it is.
Can we still read the Supreme Court judgment in full unaltered?
I don't know if he's deleted anything, so I would take it as a creation, and I apologize for your name, sir, it's on the page, right?
John's.
Cancellara.
Kent Solerich. Did I get close to that?
Yeah, it's perfect.
Hot dog. As a creation of his. This is his created exhibit. It's not the Supreme Court case. He's used the Supreme Court case to create an exhibit. And I don't think you're going to get confused because you have the working stiff case. So, and you, Mr. Johnson, can argue why he's wrong in all of his conclusions. But the court tells us all the time, I'm going to let it in, Mr. Bolt, I'll give it what it deserves, which sometimes is nothing, but sometimes it's powerful, so.
And what I did is I put it in a box, completely separated it.
Yeah.
As he can see.
So that's why. He has highlighted other things, which I would take are the actual words of the opinion, when you've highlighted.
Anything in the box is mine, everything else is the opinion.
Okay.
Okay, so do we,
We need copies of it.
You haven't been given yet, so that's his
Do you want
document.
me to take that back, or?
Or I can have one if it's always helpful. Just find what they're referring to.
I have it.
Is that a different thing than?
No, that's what I read. That's my statement.
Okay, do you have,
Additional copies for the,
May I submit it?
yes.
So is the statement attached? No?
Yes, this is what I my
Got
statement.
it, got it. Thank you.
And
Now I
that's the
understand.
document.
That's right.
Yeah. I
You're welcome. Thank you.
Okay, so, all righty. So we have noted the objection on the part of Mr. Johnson to the form of this particular piece, and our board will take into consideration.
Any questions or?
So, all right, do we have any questions? Okay, so what I understand in brief, what you have argued is that just as the town has argued that by changing the wording in March of 2022 to prohibit, that actually we had sufficient wording since 1987 to prohibit the use of STRs, at least in Edelweiss.
90.
1990. Oh, yeah, that's right, yeah, because that section was added, yeah, right.
My argument here, I didn't have access to that, so I used what was online that I could find from the Madison site, which is 18.
Right, yeah, so
I just want to be clear.
we don't know the exact. Okay, so what's the date of the, that would be potentially important. What's the actual date? 2018 is the date of the, where I'm going with this is,
the date
they've
of
been operating since 2017.
17, yeah.
If 2018 is the first evidence we have that your argument is valid, we still have a year, before that.
So, I mean, I guess I can't ask for a continuance, but I can grab probably, if I bring it back to you, 2012, to show you what that is.
Well,
You
the
see what I
town,
mean?
the town may have,
These need to be looked at.
right. Okay, so we've heard your argument. If there's anything else the board wants to ask, then I think we could,
Mr. Johnson, have a rebuttal.
yeah. Do you want to,
Mr. Chairman,
Yes.
for the record, I do have the 2015 ordinance.
okay,
I have the 2015, the 2018, and the 2022.
okay. So 4.6.
I'm looking at 4.6. Primarily a district of single-family residences and accessory buildings. One dwelling unit shall be the maximum allowable on any one lot in any one building. Other permitted uses include home occupations, churches and public buildings, business, commercial enterprises, and agricultural uses are prohibited. So I don't believe that from the 2015 to the 2018 to the 2022, there has been any change in 4.6A.
That is correct.
However, also relevant would be the definitions of things like business, motel, et cetera, et cetera.
Let's see.
Business was never defined.
Yeah, business isn't defined in
no.
any of it, but. Motel, a building or series of buildings in which lodging is offered for compensation with direct independent access to and adjoining parking for each rental unit. That also is in the 2022. That's not changed.
Yeah.
That's exactly the same.
And my point is that is a better definition than just simply going by residential purpose. It fits that mold, commercial, business, and motel.
Okay, all right, thank you. Mr. Johnson, did you want to rebuttal now, or?
I think the Conway case, yes, it related to the zoning ordinance, but the Supreme Court made a general statement that using a property, how you decide whether it's commercial or residential is how the property is used. And the court said using the property for a residential use, which is short-term rentals, does not convert it into a commercial use. I would note as well that the entire reason we're here doing these administrative appeals is that the town of Madison, through their code enforcement officer and the Board of Selectmen, initiated these actions and cease and desist only predicated on the change in the zoning ordinance in March of 2022. And to my knowledge, there weren't any enforcement actions or any argument that the town had the ability to take any enforcement actions until the zoning ordinance was changed in March of 2022. And to that point, if the town of Madison already prohibited by the language of its zoning ordinance short-term rentals, there will really be no reason to have an amended ordinance to prohibit short-term rentals. So I just think the logic falls in on itself, and I also think it's somewhat secondary to the issue before the ZBA, particularly for this appeal, when there is 5 years of use. So whether the use is pre-existing, my client's purchase of the property and going forward, so whether the prior owners didn't comply with the property or my clients didn't comply with the property, it's all then still it's still a continuing use of the property and allowed. So I mean, if it changed at some point, it doesn't, I don't think it alters the analysis,
Just whether it was legal,
particularly for this case.
and that's what he's bringing up.
Thank you. People have to get sworn in for every case.
Okay.
Or can it be-
Do we get to, no,
Once he's sworn, he's
yeah, you're okay.
sworn in.
You're,
I just want to make what I consider a distinction. Everybody argues residential use.
excuse me, do state your name again.
Oh, Bob Boyd.
Okay.
So they're arguing residential use, and I understand the court decisions, the arguments here. I personally believe there's a difference in residential use between a homeowner living in their home or a long-term rental person living there, a family, versus residential use for profit. I believe there's a difference.
Thank you.
Do we have, excuse me, did you want to speak? Come.
I'm Karen Dugosinski. I'm at Washington Drive. I am reading some documents written by Kathy Kozel from Lakeview Drive, and she has submitted these documents prior to this meeting. January 17th, 2024, reference public hearing, 13 Lucerne Drive. To ZBA members, I respectfully submit new information regarding case 2313 that has come to light since the continuation of this case on November 15th of 23. Attorney Matt Johnson argues that this property was used for short-term rentals historically, and that the property always has been used for short-term rentals, and that the use has not been abandoned. This is absolutely false. Attached is an email from the property owner that built the home in 1985 and used it as his personal vacation home until 1995, when it became his primary residence, until 2015, when it was sold. In addition, attached, which has already been submitted, is a review of court cases and arguments that support the town's 1987 ordinance that use of dwelling unit as a short-term rental is not permitted use. The March of 2022 amendment does not give short-term rental use grandfathered status, as it was not a lawful use prior to that amendment. In 1990, the ordinance was extended to include Idlewise, which has an additional language that expressly prohibits business, commercial enterprises, and agricultural uses in the village district of Idlewise. As there is no proof that this property has been used as a short-term rental at least once a year since 1990, it should be considered prohibited. This in addition to the fact that the business, commercial enterprise, and agricultural use is also prohibited in Idlewise. Interestingly, two Mount Washington Valley Associate of Responsible Vacation Renters board members submitted to town evidence of rental history prior to the adoption of the 1987 Madison zoning ordinance. They were attempting to demonstrate continuous rental history back to that point. Based on the evidence that this property was not always a short-term rental or used for short-term rentals historically, actually far from it, please deny the applicant's request to vacate the notice of violation. Respectfully submitted, Catherine Kozel, Lakeview Drive. And this is an email that was sent to Kathy Kozel from the original owner. 13 Lucerne Drive from Mike Stagliano. to Kathy Kozel, December 30th, 23. Good morning, Kathy. I am Mike Stagliano, and we received your letter yesterday. My house on 13 Lucian Drive was never used as a rental when I owned it. I built the original house in 1985 as a weekend getaway and vacation home while we lived in Medford, Mass. We moved up there permanently in 1995 and put on the addition of the garage and master suite. We sold it in 2015 to a couple with college-age children who said they were going to use it as a vacation home. We found out later they were renting it through Select Realty. So for the whole time we had it, it was not a rental. If you need any more information, feel free to contact me, Mike Stagliano, 603-455-8536.
Sorry, Mike, for putting your phone number out there.
Yeah, sorry, Mike.
Hope he doesn't get any calls.
Okay.
Mr. Dempster.
Chairman, I apologize. Please, I wasn't going to say anything, but I have some information, certainly.
Yep, and you've been sworn in already this evening, so.
There were references made back to 1980.
Your name
I'm sorry,
again.
Bill Dempster, Madison. There were references from prior speakers that were made regarding when Edelweiss became adopted under the Madison zoning. And what you have is the 2022, you have the 20, I think Mr. Bolt was 2015.
28
This
to
is
20.
this is the 1990 Madison zoning ordinance. I can provide that to you so that you at least have a copy of this. Would you like that?
Sure.
Okay. I only have one copy.
If you give it to Kate, then you could pick up your copy again tomorrow after she copies it. She can make a copy and you can have your.
Oh, sure. Okay, that's fine. Thank you. I figured you needed it. We were going back, so.
Yeah.
you have
So,
it.
Mr. Dempster, let me ask you, since I don't have this in front of me, and
Hold on a second. This has what looks to be cuts and different typing. Do you have an original from the 1990?
I would have to get that at my house. What you have there is the exact same as the original.
With cuts.
No edits?
Yeah, well,
There's underlining. That's
yeah,
what
they're
he's discussing.
underlining, but it's different. There's different fonts. There's different.
That could be valid.
that could be, yeah.
It is a,
Either way, it's
yeah.
rock and roll. Okay.
It's. I did put a request in for that information at the town hall, but I actually found that on the UNH library webpage.
Well, again,
That's up to the board.
that is for your quasi-judicial purposes, that is a okay reference, and you give it the weight it deserves. And Mr. Johnson, want to say what's there? I mean,
I'm just going to object. I mean, I think if we're going to go back to actual ordinances, I mean, there should be a way. I have an objection to ZBA looking at the 1990 ordinance, if they want to look at it, but why don't we find a copy that we actually are assured is the 1990 ordinance? I mean,
Right. No, I
that would be my
understand, yeah,
point.
that's a valid point. That's-
subject to check is, again, the way we deal
So
with it at
subject to
times.
verification that
Right.
that is the 1990.
So, I mean, if it's at the UNH library, there ought to be one in Madison Town Hall.
One would,
And
But it may
Madison
not be
Library.
online.
Well, I
the
don't
year
care if
the
it's
town
online or
hall
not, yeah. Oh, yeah.
Actually, I had a copy given to me by my neighbor who passed away. It was the same
yeah,
thing.
it's one of those things.
Yeah.
The concept is hearsay, and we want to make sure that we're relying on, not to cast disparagement to anybody, it's, you want the evidence coming in as the correct evidence, the legitimate evidence. We gave to Mr.
Oh, Cancelarich?
Gellerich?
Cancelarich.
Cancelarich. You know, it wasn't the real case. It was a modified case, so we needed that distinction in the record.
Yeah, totally understand,
Right.
Attorney Bird.
Okay.
It was meant as a reference. However you use it, you choose to use it, it's up to you.
And I take it your point for that is it has the same language. on
Correct.
Edelweiss
That's what I was going to ask.
Correct.
at 4.6.
Anybody else wish to speak to this case? Okay, then I think we need to begin to collect findings of fact.
Yeah, I can change.
So that's yours to keep, to make a copy, to give him back that original. Well, it's his, yes, you want to confirm, but
Okay, so this is preliminary, but first of all, relevant finding of fact for there's a change in the ordinance in March 2022. Secondly, we have evidence,
my apologies.
Yes.
No, you're still in public hearing, correct?
yes,
That's your practice. Just wanted to
Right.
be sure.
yes. Yes, because this allows the public to add to the findings of fact or correct them. Okay, so changing ordinance, March 2022, that's the key date here. We have evidence from 2017 of continuous short-term rental approximately, we'll just say 50 to 80 days a year. Three, there's no lapse in that time frame. The date of, let me rephrase that. Let me see, how do we want to say that?
Say which, I'm sorry.
Well, I'm trying to capture the question that was raised as to whether the March 2022 date is relevant. Now, we're going to have to debate that issue, but the question is, how do I state that as a statement of fact, that the March 2022 date is contested?
Just like that,
Okay, yep.
right?
The March 2022, I'm saying relevance of the March 2022 date.
And I would say in light of section 4.6 concerning Edelweiss, is the argument.
Is contested.
Whether it's controlling or not, that's your determination.
Right, okay. So the relevance of the March 2022 date is contested in light of section 4.6 and supporting definitions, in particular motel, commercial use was another definition that was mentioned. Is that correct?
I believe that's what he said.
I think it was business.
What were the
Commercial
definitions that you used in particular? Motel, commercial use?
And business.
Okay,
Can't find it, 1990.
Commercial use.
right. Okay, so I'll restate, his comment was that because I asked what were the words, the definitions that were relevant to the interpretation of 4.6, his comment was the definition of motel, the definition of commercial use, and the general definition from Webster's Dictionary of business. Are there other Well, okay, so the validity of the grandfathering,
So I have a question, though. I do have a question.
yes,
We have all this evidence with regard to the prior owners renting it that I'm aware of. Do we have any evidence of when you started? It says the second half of,
Yes, it's in the packet.
You started on August 5th, 2022, with the current.
It's actually on the back side of the chart there. That's our rental history, and I highlighted the first date that we
right, here,
rented,
Sharon.
was August of, yes.
which
I
points
see.
out that there's only a 24-week lapse in rentals between ownership.
Oh, and just, do you need to swear? I don't know that you swore my client in, just for your procedure.
Oh, yeah, why don't we just go ahead and swear you in, just so that we,
To be fair.
yes.
Consistent to everybody.
Do you swear the testimony that you give and have given pertaining to this case is truthful under the penalty of perjury?
I do, yes.
Thank you.
Want to restate it, or?
No, that's fine. No, we got it. Okay, so I was beginning to state that the validity of the grandfathering was challenged on the basis of the date of 4.6 in 1990. Okay, so that brings the relevance of the, specifies that. So at this point, I have 5 findings of fact that are relevant to this case. We can add to them or correct them. March 2022, change of the ordinance. We have evidence from 2017 of continuous short-term rental of approximately 50 to 80 days per year. We just specified that with no, there is no lapse. It was only a couple of weeks. The relevance of the March 2022 date is contested in light of section 4.6 and the supporting definitions of motel commercial use and the general definition in Webster's Dictionary of Business. And the validity of the grandfathering was therefore challenged on the basis of this date, 4.6 in 1990. Okay, which predates the 2017 by quite a few years.
Question, Mr. Chairman. You had some testimony, it's your question of whether or not you feel it's relevant, on the original owner who built the house in 1985.
Yeah.
That bridges up to 2015, that he
Oh, yes.
did not rent the property. So that gives you a factoid that may distinguish another case.
Yes, but that bridges the 1987 date, which
Correct.
settles, okay, so then the original owner testified, he built the house in, what was that, 1985? 1985, and sold it in 2015 without ever renting it. Okay. 6 points. Did you want to add something?
Just on the number of days, I did the average of it. I don't know if that.
Oh, that's fine, sure. No, that's
The
fine.
average between 2017 and 2023, the average number of days rented according to the applicant's numbers was 55.1428571.
I don't know how you could rent a house for .14285.
That's like 10 minutes.
Yeah, okay, okay. So approximately 56 days average.
Yep.
Right. Way out of whack.
Okay, okay, so we have 6 points of fact here. Any further additions, corrections?
I don't know how we state that.
Yeah, just 1 second, Nancy. Go ahead. Come back up to the microphone if you have something.
2 articles I mentioned, there's 4.6.
Yeah.
Can you state your name again, sir?
I'm
Sorry.
John Kancelarich from Melrose, Massachusetts. 4.6 we mentioned. There's also Article 2.3, which says compliance requirement, all buildings and land within the town of Madison shall hereby be used, laid out, constructed, or altered only in conformity with the permitted use and requirements for a district in which they're located. So it's basically re-emphasizing the permissive use statement. So it's Article 2.3, the 4.6, and lastly, as I mentioned, the last article that's important to this is the 21E, last sentence, which basically says that the town, if they don't enforce it, does not give up the right to a district. That's 2.1E.
2.1E.
I believe that's correct. I don't have that in front of me. Is that correct, 2.1E? I wrote on the back of your on the front of your sheet that I gave you. You look up
2.1E, last sentence.
Yes.
Failure by the selectmen to not initiate enforcement under this ordinance will not constitute a waiver of the town's right to take such action.
Thank you.
Okay.
Those are my primary ones.
Okay, so any other clarifications on points of fact by the board?
You want to talk about that?
Yeah, I want to, now that we've pointed this out with the average number of rentals, I do want to point out that from 2017 to 2022, the average rental was, the least was 41, the most was 67, giving you an average of about 51 days. But in 2023, those days went up to 78 days, which was a higher level of use than had been previously used in the home, going back the 6 or 7 years, 6 years that it had been used. And I think it's perhaps an escalated use of a property from where it had been historically. And I think as we're talking about existing non-conforming uses potentially, that I do know that within the construct of the ordinance, while you can continue a non-conforming use, you cannot necessarily expand the non-conforming use, whether it be footprint size or if you're looking at a structure of a home. But if we're looking at short-term rentals, you can't necessarily expand, in my interpretation, the number of days or the frequency with which you're then going to be using the home if historically you'd only used it, say, 50 days a year. I don't know how you put that in there.
Well, we can just note that the 2023, okay, so, excuse me, when did he purchase the house? It was August of,
June 10th of 2023. 2022, sorry.
Yeah, so in his first rental usage was August of 2022. So, in fact, 2022 was relatively low. Well, okay, the answer to the question is we can put in a statement of fact that it appears that 2023 is an increase.
Yeah, well.
We do have at our disposal the possibility of putting in a condition that limits to, say, 80 days a year, 90 days a year, 60 days a year, whatever we want, okay, that we feel is consistent with the non-conforming history. Okay, we don't have to be terribly precise on that. That is, it doesn't have to be 55.187623.
I would keep a whole number.
Yeah, exactly.
If you're going to go through.
I was only going to say that Sharon asked how we would deal with that, and the answer is that's one way that it could be dealt with. Okay, you wanted to make a statement.
Yes, Chad Zoni, 13 Lucerne Drive, Madison. If I may, the numbers that you're looking at with the 78 days in 2023, although a higher number, the rental days, the average number of rental days was actually higher in 2017 at 7 days a month, just because it was only rented for half the year. So it was actually rented more, the most was rented in 2017, with 2013 being the second.
No, that's relevant.
If I may, I'm saying
the choice
if we
to rent it.
extrapolated 2017 numbers to a full 12-month calendar, we'd be roughly looking at 100 days of rental.
Possibly.
40.
You'd have to do the math, but
It's
yes.
49 days
Yep, so
per
80,
6
98
months.
days. Yep.
Yeah, okay.
In theory, yep, exactly. And I will add that our is is a second home mortgage, so we're only allowed to rent the house X amount of days per year, because it's not a business. So we are not permitted for renting the house.
Do you know what that number is?
It's 180 days,
Yeah.
because we have a residential mortgage and not a commercial.
Right.
'Cause the
Yes, and I
house
see 2022 is also
As your
just,
resident.
as a second, yes.
Right, as
Because
opposed
the fact that
to-
it's a second home and not a primary short-term rental, we're only permitted to
Primary
rent the house.
It's about
Or
8
long-term
days.
rental, so we're only allowed to rent the house 180 days per year.
so that's,
So if you take another quarter of that,
But I argue that, not to get you, I would argue that the homeowner in 2017 had the ability to rent the house, however many days.
13, 40,
Jake.
52. I'm sorry?
The homeowner in 2017 had the ability to rent the house however long they chose. The fact that they chose not to rent it for those 6 days doesn't change the number of days.
I'm just clarifying his statement that he's saying if you extrapolated it out
Right,
based on.
because there is no way
Yeah,
to
but I
tell.
don't know that that's relevant.
Right, no,
is
just
what
because there
I'm
is no way
saying.
to tell.
Because there's no way to
Why
tell.
they started, when they
Correct.
started. You know, maybe they rented privately beforehand, before sold.
Right.
There's no way to tell.
So all we have is the
I was going
actual,
off the average number
Right.
of days per month.
right, but we also have this similar situation in 2022 where, you know, they, only 8 months of the year were 40 days. Yeah, my point is, we're not trying to be extremely precise on the number of days. We don't want an expansion of the non-conforming use, but we also don't.
I don't want to overly restrict it if
Right,
that's the.
yeah, exactly.
I think,
That's
I
what
think the average number we have come up with is a good representation of its history.
Yeah, but, right, yeah. And if we so choose, we can make a limitation based on some extrapolation based on that. Yes. Everything else you want to say? Thank you. Mr. Buckley, I don't think I've sworn you in tonight. Did we?
No.
No.
Not
Okay,
yet.
okay, that's fine. Do you swear that the testimony that you give pertaining to this case will be truthful under penalty of perjury?
I do.
Okay.
I just have a question, Mr.
Name,
Chairman.
please.
Name is James Buckley, 58 Ottawa West Drive. I just have a question about the process. The applicant that we just heard before my speaking, he was denied by a decision of the selectmen about having an STR. And could you just read the letter and the reason in zoning as to why he was denied?
Okay.
I'll make sure I understand that correctly.
Which case are you asking about, Jeff?
This one.
This case.
This one?
Okay, I heard prior, and so I was confused.
Prior speaker.
Okay, the letter of, the notice of violation.
Sorry, good, it's good.
Adrezonian Clymer, is that correct? Yes. All right. You are receiving this letter because you have been identified as the owner of a non-owner occupied property located within the Edelweiss residential district that being offered for rent as a short-term rent. You have previously received a letter informing you that this use is not permitted, and you've not responded. Section 4.6A of the town's zoning ordinance states that the Edelweiss district is primarily a district of single-family residences, accessory buildings, with only other permitted uses being home occupations, churches, and public buildings. A March 2022 amendment to the zoning ordinance clarified that a house that is used for transient occupancy, i.e. rented to guests for short periods of 30 days or less, does not meet the definition of a single-family residence. You are hereby ordered to cease using the property as a short-term rental immediately. Please be advised that if you continue to use the property in violation of the ordinance, the town of Madison will commence legal action in court. Pursuant to Section 2.1E of the town of Madison's zoning ordinance and RSA 617, failure to comply with this order may result in a civil penalty of $275 for the first offense, $550 for the subsequent offenses for each day that the violation is found to continue after the date on which you receive this notice. Each day that a violation continues is a separate offense. Should you not voluntarily remedy this violation, the town may seek injunctive relief under RSA 676-15 to enforce this order. Civil penalties under RSA 676-17, and 3, recovery of the town's attorney fees and costs under RSA 676-17, paragraph 2. Pursuant to RSA 674-33, 1A, you have the right to appeal this notice of violation to the Zoning Board of Adjustment within 30 days of this letter.
Thank you, Mr. Chairman. So if I'm hearing you correctly, the violation was renting the home, starting to rent the home as a short-term rental after March 8th of 2022, when the definition of dwelling unit was put in place.
And Idlewice.
Well, in Edelweiss and after March 2022.
Okay.
I don't know how Mr. Boyd, selected those, or how he was getting names. But he was simply identified someone who was renting after 2022.
So the findings of fact, she related to whether the rental history existed prior to March 8th, 2022, and continued after the zoning change to dwelling unit.
Well, we have stated that March 2022 changed the ordinance, and there is, secondly, that we have evidence from 2017 that there is continuous
Short-term rental.
short-term
Yes,
rental.
from the applicant.
Well, no,
There's just evidence.
previous
owner.
previous owner, and the however, that establishes a pre-existing
Yes.
use.
Okay.
And this current owner then began his rental in August of 2022, so that was after which is probably why he got caught in the net.
Yes,
is because he bought the after, and,
Okay.
yeah.
I just want to make sure we're focusing on the findings of facts relevant to that
Right.
change of definition. Thank you.
Still don't understand his point.
Okay. Okay, so, yeah, I'm gonna, parent usage, okay, so I'll add that, to the finding of fact that the current owner began rental in August of 2022. Okay. Any other comments on findings of fact? Nope. No, okay.
Mr. Chairman, may I
Yes.
ask for clarification?
Yes.
You added what I was writing down when you asked the question to everyone. Current owner began renting in August of '22.
Right.
You had, and I'm sorry with the hour, I'm starting to blur the cases. Do we have a finding of fact in this one? Yes, second one, evidence from 2017.
Yes.
I just wanted to make sure we had both ends.
Yes, we have both ends, right. Okay, in that case, then, any other questions from the board? We can close the public hearing.
I don't know if it's necessarily pertinent, but when you look at the tax sheet, it indicates the house was built in 1984, that there were 3 bedrooms, 3 bathrooms, yet the house is advertised, I believe, as 4 bedrooms, and in fact, when you look at the occupancy, there are as many as a dozen people in a technically 3-bedroom structure.
It's an interesting observation, but how does that specifically relate to?
Well, I'm sorry, I didn't mean to cut you there.
No, no.
I'm just wondering as we're going forward, with if we're, as you stated, able to impose limitations, are we then able to necessarily impose that since this is advertised as a 4-bedroom house, that generally there should not be necessarily any more than 8 people occupying that home? Or that if it's in record as being a 3-bedroom house, we impose the restriction that there should not be able to be rented to anything more than 6 people?
Well, in principle, we are allowed to impose any reasonable condition on an approval.
Okay.
Whether we think we're competent to do that is another question. Well, I mean, you just, I mean,
Is there a standard
Why is it
expectation
such
that
difference?
four
Why is it
people
Tickled me greatly.
occupy a
I'm
bedroom?
sorry, I've been up way too long, and I've got to get up tomorrow morning to get to, but that just struck me as funny.
okay. All right.
Is there a question of, is there a standard?
Is there a...
Frequently, there are other towns, whether in their ordinance or when they're creating conditions, are 2 persons per bedroom plus 2.
Okay,
Because you might have kids
yeah.
that,
Pull-out couch.
or whatever.
Whatever.
But it's one where it's gauged the septic system. So if the tax card says it's a 3-bedroom, that usually ties to a legitimate septic system. There can be an oversized system, but those are frequently noted on the card. My house, we overbuilt the septic system when we had to re-put one in. So I have a 6-bedroom septic system, but I have a 3-bedroom house.
He testified, the applicant testified he has a 1,000-gallon
Gallon
system, just for,
1,000 gallon per day or 1,000 gallon septic tank?
just says 1,000
1,000
gallon.
gallon
It is.
septic tank.
I think can take from prior case what that means, but plans, when I'm dealing with looking at a design plan, I'm looking, there's a specific notation. It's not by gallons, it's really by bedroom.
Yeah.
And it's generally accepted, as you said, that it's 2 person per bedroom plus 2.
Other towns do it that way, is the way I will say that.
Okay.
Is there a rule? No. 2 persons per bedroom plus 2 gives you some play in the joint for kids to be.
Unless they're from adults.
But it prevents you from having 40.
Right. How did you come to the size of your, did you just do it, or did you get Airbnb or somebody give you advice and
In terms of the size of the house or the
size of the number of occupants?
So when we bought the house, it was a 4-bedroom house. As previously stated, there was an addition put on in 2015. So it was a 4-bedroom house, an addition put on in 2005 by the original owner. I believe the woman that wrote the letter said that the original owner stated he put the addition on in 2005. So when we bought the house, we in fact bought it as a 4-bedroom house. It was a loft. And as the previous owners were renters, one of the bedrooms does have bunk beds. So including the loft, the bunk bed, we are actually able to sleep 11 bodies in beds, as well as an additional 4 if you count the 2 couches and a futon. We keep it maxed at 12. Just doing some quick math while I was sitting here with the septic. If you take our max number of renters, 12, multiply that out by the 78 days that we rent, it comes out to, and then you would add in the time that my family personally uses the house. We are roughly occupying the house for 1,212 days, or let's say 1,212 human bodies in this house, over the course of a year.
People days.
Whereas, human days, I don't know how you word that, but if a family of 5 was living there, again, 4-bedroom, husband and wife, or parents with 3 kids, 5 people living in that house for an entire calendar year comes out to 825 human days, if you will. So in fact, the rental usage currently, along with our personal use currently, we're actually underutilizing the septic by what it could be had it been just a family of 5 living in the house full time.
I heard different
I
numbers.
heard different numbers.
1205.
1212 would be our current with renters and us personally.
And then I heard
800
800.
for a family of 5.
1825, 1,800.
Oh, we
yes.
missed-
So it's
There you go.
1,200 Yep.
Okay, missed that whole 1,000 bar.
So it's 1,212 human days, if you will.
Got it.
With current renters and our personal use. And it would be 1,825 human days, if you will, if it was a family of 5 living in the house year-round. So effectively, we have 613 human days that we're underutilizing our septic system.
Okay. I understand the concept.
Given my
Yeah, I'm
appreciate
not
you getting the
sure.
right number.
Yeah, not my lack of knowledge on septic. Yeah.
Okay, we got one more speaker who wants to speak.
That's not how septics work, okay?
No.
They're designed year-round.
Point of order, Mr. Chairman.
Sorry,
Oh, your name again?
Nick Borelli. That's not how they work, okay? He's totally off-key. That's the worst thing you can do, is not use a system, keep it dry, and then flood the thing. You're making a big mistake. Doesn't work that way. And you know, I just want to go back to one thing. When I invite somebody over for a meal, and they come, we enjoy and have a good time, and they leave, that's a residential use. But when I have somebody come in and I make a meal for them and I charge them, that's a restaurant. That is not commercial. That is a commercial use. No different with the STRs. You're paying for a service. And if you go back into the ordinances, it actually I'm going to say back in the 80s, late 80s, I should say 80s, between 80s and 90s, there's an ordinance in there that's been strengthened that said what commercial use is, and it talks about that.
Okay,
Thank you.
Okay. Any other questions? No. Okay. Motion. Move to close the public hearing?
So moved.
Second.
Okay, all in favor?
Aye.
Aye, okay, so that's unanimous, Kate. Okay, so the question here is, we have our statements of fact. The critical question here, to be consistent with our previous discussion, is that we're holding the ordinance to be valid. The question is whether it's a valid claim for grandfathering. And the public has contested that the date of grandfathering that we were using in March 2022 is incorrect, that it should be adjusted to something like 1990. So that's the essence of what we have to debate. Now we can we do have the option of saying we need to do more research on this, and we will continue this case until we have satisfied ourselves that we have considered this contested issue, so that we can make a decision next month based on a consideration of more informed decision. I don't feel under any pressure to make a decision tonight. However, I'm only one member of the board.
I would think we have enough information to make a decision.
You do or do not?
I do.
You do.
Personal opinion.
Sharon, what are you thinking?
Well, I do understand the contention that the 1990 ordinances and going forward have never allowed short-term rentals based on the fact that in Edelweiss. That's because the ordinances were different. Edelweiss has not changed their language since 1990 for 4.6 or 2.3, or I forget what that actually, if that's the right number or not, and has been consistent with its interpretation and its application of what is a business, what is a commercial use, what is a dwelling, what is a motel. And so I think that question is highly pertinent to this particular case, not others, but this particular case. So yeah, they're all on their own.
Cases that have very,
Yeah.
very similar issues.
Right.
Yeah.
So I think it's important for us to be clear and completely satisfied with regard to what we believe and what we know regarding that ordinance.
Right. So to summarize, the key points of the argument on the one side, the people from the town have argued that 1990 is the appropriate date based on a normal application of the understanding of the definitions of terms that apply to 4.6, in this case to Edelweiss.
Right.
Okay, Mr. Johnson has countered and said, well, if that were the case, then it wouldn't be necessary to have changed the ordinance in 2022, and that argument collapses because no one was ever taken to court otherwise, and of course there was the back and forth, well, just because it wasn't enforced doesn't mean it wasn't in force.
Right.
However,
And to indicate that, if that were the case, there would have been no reason to further specify with the March 2022 ordinance. We change ordinances all the time. We get more specific. As culture change and as uses change and as things like, nobody ever heard of short-term rental before in 1990. It didn't exist.
Right.
It was either, you did a rental for a house for a year lease, or you did, something.
you might do a couple of
month
weeks
to
in the
month.
summer.
Yeah, you might do a couple weeks in the summer, that kind of thing. And as that changes, we have a responsibility, the town has a responsibility to make sure that everybody understands. And in fact, this town started that process prior to 2022, I would say almost 2 years prior, was it? Like 2020, we started the town started the conversation?
I think the first documented discussions was in June of 2021.
No, because didn't in 2021, we try to vote on something at March, and it didn't pass, and we didn't do it because the language was so terrible, so they gave another at 2022.
Probably 20.
Yeah, so in 2020, fully 2 years before this passed, the town was in discussion about how to approach this. And so I think it's important for us to get that part of it right, and to get that part of it, I don't want to say right.
Where I think
get
you're
it
going
nailed
with
down
this
where
is we need to know whether the 2022 decision was really just to reinforce what everyone was hoping was already clear, but wasn't because of the change in the situation. That's what you're...
Or was it to impose a whole new standard on the town, which I don't know that it was.
Okay, Chris, you want to...
May I... A rule of statutory construction, which the court will apply to interpreting zoning orders, is if the language is not ambiguous, you don't look back to intent. You look at the language they chose to use. It's horrible when dealing with the Golden Dome in Concord. They're at least have some records, but they're very muddy. I will wager heavily that we have nothing clear, and I believe, yes, I did look back at what we had in the planning board records, which is where the board that considers these. And it's not abundantly clear of why specific language is chosen. It is abundantly clear that it's this boom of Airbnb. But why particular language is, or do we need to clean up Edelweiss, I'm not recalling that being the driver. That said, you are the arbiters of what your ordinance means. You decide, in your experience in the chair, experience in your neighborhoods with this ordinance, what does it mean? You have the 2022 amendments. You have the Edelweiss language. We have the Conway case, which does not have the exact same language that you have, but there is enough in it that makes me question how the court will interpret the Edelweiss provision. There's enough in it that says residential use, it's not determined by how many days you're there or whatnot. And the town was arguing, and the people were arguing, that's a commercial use. So I'm not, with all due respect to the folks in the district, I understand the point. I'm not sure it completely controls based on the case law we have. I can say this, no matter what decision you make, somebody's going to be upset and has the right to appeal. And it's accordingly, where do you think the strongest position is for you? Is it a denial because it's Edelweiss? Is it an approval because it's grandfathered with conditions? That's why you guys get the big bucks, both of them. And you have to make that call.
Okay, so we're discussing whether we wish to do more research, whether we have whether we just want to make a decision.
Where are you going to get more research?
Yeah.
You also do have a timing issue. This has been continued with the grace of the applicant for a number of meetings because you haven't had a full board.
Right.
I'm concerned about
That
going
being done.
further.
Yeah.
We're also after 8:30, and you have
Right.
a number that will have to be continued already.
Yep.
And one decision may make the others decide whether they wish to proceed or not.
Okay, let's go for a decision.
You're on the wire.
Oh, I'm on the wire.
Yeah, you're on the wire.
Sorry. Technicalities here. Alrighty. So, all right. Well, let's go ahead with the decision. Okay. We have our findings of fact. There were 8 of them in round figures. The question is, we have absolutely solid evidence that this unit was rented prior to 2022, at least since 2017. So the decision we have to make is, do we accept or reject the argument that 1990 should be the date? That argument, in summary, as I said, was based upon the normal interpretation of 3 terms of definition, which is kind of a parallel argument to the argument we have on the decision as to whether or not we would accept, the wording of our current ordinance hinged on the definition of dwelling unit, transient usage, and non-transient usage. So basically, both these arguments are going to hinge on our understanding of what drives our understanding of the ordinance. So, to put it, now, we could discuss this briefly, but I just submit that then the argument is, does the definition of motel and commercial usage define the ordinance as being valid in 1990, or does the addition of the terms transient, non-transient, and dwelling unit definition in 2022 become the driving determinative factor? Comments? George, you have an opinion?
I just feel that this is a unique case that qualifies for, different than the previous case, a possible acceptance. He's got 4 or 5 years of steady rentals.
Right.
And that when we went into this, that was the charge that we were kind of given, is that as long as they had previous consistent, it's the time factor you're talking about, and I can't answer that.
Right, okay, so you're not decided on that at the moment.
Yeah.
Jake, what do you think?
I keep thinking back to when, if there is a violation of something and it's not done, and nothing's done about it for so many years, what what power does the town have to do something about it? But you're right, the question of when they enacted in 1990 by stating motel, whatever, I think a motel is transient housing. I believe it's inherently the same. You go to a motel to vacation, you're not moving there permanently, you're not changing any government documents to go there. You go there intentionally with a short time to leave. That's my opinion on it.
I was prepared to agree that renting it back to 2017 would allow them to go forward until I heard or I read the Edelweiss document, which is, from my point, is very clear. It says no personal or commercial use. Now, a motel, one of these houses is essentially a one-unit motel. So I think that, from my point of view, my opinion, we have to listen to what the intent of Edelweiss was in 1990, which was not to allow these things. And the fact that it hadn't been enforced is irrelevant.
Sharon, do you want to venture an opinion?
I believe that when you transact something for money, it is an economic transaction. It may not be defined as commercial because there are some specific, but I think that someone could and would reasonably suggest that you are conducting business in that home or in that dwelling. I think that in 1990, as the ordinance was going forward, the fact that it specifically called out that you could not transact business or commercial actions in Edelweiss. Edelweiss is different than the rest of Madison. Edelweiss was more specific. And so in order to, potentially preserve the rural nature of the neighborhood, and I believed, and I too was prepared and thinking, okay, he's got a good case, 2017, he's got evidence going back to that, it's prior to the 2022. But again, looking at from 1990 to 2022, that ordinance never changed. It didn't need to change because it was strong enough in the wording and the information. The definition of a motel is very, very clear in there and very specific about having your own independent entrance, you have your own parking, and I think that what you just said, Doug, that each one of these short-term rental homes is operated like a motel. And I think trying to get around that is going to be tough. You're transacting for a short stay. And as Jake said, there's no way to construe that as living there permanently because you've not changed any government documentation to that address. You're not representing it as the place where you live permanently in order to go to work every day and back. It is a vacation short stay. I have a hard time, even though we changed the wording in March of 2022, I believe that March of 2022 wording dealt more with the rest of Madison as opposed to specifically to Edelweiss.
I agree.
Because I think that was bringing the rest of Madison more in conformance with what Edelweiss had been doing.
So, okay. All right, that's where I was going to try and summarize where you're going with this is by interpreting motel commercial use.
Not commercial, I say business.
Well, right, except that business was not defined. Commercial use was, but he provided a suggestion. But your point though is well taken, is that if we accept the March 2022 change as being valid, which we have done, then understanding those words are consistent with that particular understanding.
Correct.
As opposed to creating. Okay, so I'm not going to put you on the spot again. Does somebody want to formulate a motion? And then we can move ahead with a clarification of that and possibly a vote?
Let me think how to.
Let me try.
All righty, well, just say it, and then we'll write it in later.
And I'll try to, I move to deny the application based upon the,
Based upon the duck noise.
that sounds like mine.
I have a duck, so it doesn't disturb anything when I'm in the woods. Sorry.
You listen to mine. So let's try it again. I move to deny the application based upon the statements of facts previously defined.
Established, defined.
Established, defined. Good, Chris?
Well,
Findings of fact.
Yeah.
based on the findings of fact, do these findings of fact,
This is what we did the last,
it is what we did the last time, I just want to make sure.
That we have all the right findings of fact.
Because the findings of fact, we said the original, no, excuse me, we said the validity of the grandfathering was challenged. We didn't say that, I think we would have to say because we accept
Well, and I,
the argument that the terms commercial use and motel, in fact,
And idle, the 4.6
yeah.
yeah, I
the
would
key
say.
measure,
Yeah.
which you had in your findings.
okay, so if you,
Okay, let's keep
so my,
working on it.
so my motion still is acceptable as long as you correct the statement of facts.
Findings of fact,
Findings of
yeah.
fact, is that correct?
Should be.
Yeah.
Sure.
So the motion is correct.
As long as you are making reference to, you're relying on 4.6, the language of motel, the definition of motel, the definition of commercial use, and the undefined term of business.
Okay. Kate, I'll have to send you that wording.
Yeah, I'm starting to, you're losing me.
Right, but we have that here. Okay, so let's, motion deny based, well, let's do it this way. Based on the findings of fact, and we'll clarify that statement, findings of fact. Move to deny the appeal. Okay, and then the critical one is the, I'm going to rewrite number 5 here as this,
Based on the language of 4.6 concerning idle votes.
yes, the language of 4.6. 4.6A, is it, or is this 4.6?
4.6A?
I believe it's just 4.6.
Okay, 4.6, okay. The language of 4.6A,
Yes,
supported by the definitions, by the definition of motel, commercial use,
and the undefined.
and the undefined term business, in parentheses, as defined by Webster, but as defined by Webster. Supported by this language, does not permit short-term, well, should we say transient?
Transient.
Because that's defined
That's
from,
the,
does
and that's
not,
the wording in the.
does not support transient rental. Do I need to say in Edelweiss, or we've already said 4.6, that defines that?
Well, my
4.6
reference
is-
was to 4.6 concerning the idle bus.
Well,
That
right.
is Ale Place.
Yeah, okay, well, other cases, we may have to visit with this.
Right.
Okay, so then that's basically the way we said it. The language of 4.6, supported by the definitions of motel, commercial use, and the undefined term business, but as defined by Webster, does not permit transient rental. Is that close enough for? Okay, so is that enough for us to vote on?
Second. We need a second.
I'll
You
second.
made it, John.
Wait a minute.
Yeah, he's saying.
You moved it.
Yeah,
I
he was
moved
saying I need a second.
Sharon,
I'll
second.
Thank you.
So we can vote.
Okay, so we can vote all in favor of the denial. Raise your hand.
Aye.
5?
5.
Five.
Okay. All right.
30-day appeal.
Yes, I'm just 1 second. I'm going to read that. If one wishes to appeal, one must act within 30 days of the date on this notice, day 1 being the day after the date of decision. The necessary first step before any appeal may be taken to a higher court is to apply to the Board of Adjustment for a rehearing. The motion for a rehearing must set forth the grounds on which you base your appeal. Board members are advised to refrain from any discussion of this appeal with other board members or any other party to the appeal until all appeal periods have expired. Thank you.
We call a 5-minute recess.
I'm sorry, what'd you say?
Yes.
We call a 5-minute recess, and then that'll take us to the 9 o'clock cutoff anyway.
Okay, it is part of our procedure, we're not going to start new business after 9.
That's close enough.
I think this is close enough.
No argument.
Okay, which means we will take a short recess, and then we will continue the other cases.
So
I believe every other case is also represented by
16,
Mr.
17,
Johnson, is that
18,
correct?
19,
The only other thing on the docket was a variance, and that got continued, so everything else is mine.
For
And
all-
after the break, I do have a question for you. Go ahead,
Okay.
Counsel.
That's fine.
I'll
Yeah.
ask you at the break. Take a break.
Oh, yeah,
Yeah,
we're
I
taking
gotta
a break,
go.
yeah,
We
if
gotta
the
go
two
to
of
the
you want to
bathroom.
talk. get back together in a minute? Chris, you can finish your story.
Did I hear that? I'm paroled?
Oh, for the night. Yes, we're only gonna do administrative.
But you've got to get the continuation.
We're gonna get the continuation. You don't, if you wanna wait for that, it's fine with me, but otherwise.
I'm fine, go.
Yeah. Okay, we're gonna get going in just a second.
Yeah.
83 and 84, those are 40-year-old trucks.
It is the new one.
My husband's driving around in a 2013 Toyota Tundra.
I just sold.
I think all of them do.
I just sold my. I had a 2016. With literally every.
My eyeballs, every option.
And I just sold that. The guy knocked.
I mean, somebody comes back and
Now that's a 2016.
isn't that awful?
That had 164,000 miles on it.
Let me see if they might. This one there. Did your mother tell you?
So,
Yes, okay. Thank you, Chris.
well, do you want me to stay for that so you know that I can make it, or do you need me to come the next time?
No, I don't think,
Fair enough.
I don't think you need me the next time, but. Okay, we're going to consider all the remaining cases on the docket tonight are cases that are represented by Mr. Johnson. So what we want to do, if it's okay with you, I will go through case by case number and then we'll just vote one time to continue them all till next month. Okay. Okay, so we heard case 2312 tonight and case 2313. We need to continue case 2314, which is for Ryan Finn and Grace Harrigan. We need to continue case 2315, which is for Keith and Al Kellerman. We need to continue case 2316, which is for Monica McWilliam and Laura Thompson. 2317, which is for Seamus O'Brien and Kayla Walsh O'Brien.
Seamus.
Seamus, sorry. I knew better than that.
Yes, you do.
2318, which is the case for Matthew Petty and Jennifer Swift. Case 2319 for Brian Burns. Case 2320 for Jade and Cynthia Franklin. Case 2322 for Kaylin, how did you say it, Deshen and Kaylin Couch. Case 2324 for Divine, oh, no, sorry, that's for David and Julie Keiselbach. And case 2325 for Rishi Saxena and Abhishek Shahai. I move that we continue all these cases until next month. What's the date? Is it?
17th.
The 17th?
Yep.
The 17th of April, 2024. Would we do it here, or would we do it back at Town Hall?
Let's do it back.
Back at town. I mean, we had quite a few
All right, let's do
people.
it back at Town Hall.
Based on the crowd tonight, I think that would be okay.
Yeah.
Yeah.
Okay,
At town hall.
okay, so I've moved.
What time?
At 6
Oh,
o'clock.
it's 6 o'clock.
Okay.
I'll second it.
Doug second, I moved to second. Okay, all in favor?
Aye.
Aye.
You ready?
Okay. We will continue the public meeting. Everyone's welcome to stay, but we're just taking care of administrative items.
What are you going to do
approval
with
of
this one?
minutes.
We didn't do this one yet.
23, no, that's the one I mentioned earlier.
23.
23.
I-
Andy
it's-
Moscone.
It's
he's
been
not here till
continued, it's
June.
continued till June. I said that one at
Stay
the
on
beginning of the meeting. I know, huh?
So if it's continued to June, why does he have to stay on the agenda? Wouldn't it go on the June agenda?
No, Linda said I should leave it on every month because.
Probably
That
just
doesn't
keeps
make
it
Yeah, it keeps
logistically linear.
it in our,
Right,
in our brain.
right, because we
Maybe
don't
you
want to
should-
lose track of it.
right, but I think you can probably put in parentheses,
Continue to
scheduled for June.
I can do that.
Yeah.
At the very end of it, at the bottom. in
Yeah.
parentheses.
Well, what we want to prevent is somebody in town who's interested in the case coming to the meeting to hear it and find out, because it was on the agenda, that it's not going to be heard till June.
Right.
Yeah.
So you want me to put on here in parentheses scheduled at the June meeting?
Yeah, right, that's fine. Okay, so we have 3 sets of minutes to approve tonight, and while we do that, let me just make a comment. This is the March meeting, and technically, officially, it's the vote for our officers. So I want to ask things. First of all, we have a new board member who's in the process of being approved, right? So it was suggested that we hold off the election until April, which is within our normal time frame.
Who's the new board member?
Jennifer Strafer.
What? Say it again, Kate?
Jennifer Scaife.
Steve?
Scaife, S-K-A-I-F-E, Scaife.
Scaife, Jennifer Scaife, okay, is joining us. So we'll hold off. I need to check our procedures to see whether all board members
Just
vote
pulled it
for the
up.
officers, or whether it's just the,
As,
I just
and she
had- or
joining
Just
us?
the present ones, or?
Hold
Just-
on, I just had it.
present, whether it's just the full board members, or whether the alternates also
Officers,
vote.
chairman, hold on. Chairman shall be elected annually by a majority vote of the zoning board of adjustment in the month of April. So I was
Oh,
right,
in the month of
right
April,
I was
okay.
right, that's why I didn't want to do it tonight.
Is she coming on board as an
The
alternate
chairman
or a
shall
full?
preside over all meetings and
We don't know,
hearings,
sir.
blah, 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 blah. Vice chairman shall be elected annually by a majority vote of the board in the month of April.
Okay, so I'm willing to stand for chairman again. Anyone
We're
is
not
welcome
doing it
to
till
run.
April.
Okay.
What's it?
We're not doing it till April.
We're not going to do it till April.
Right, okay, but you do.
But I do
wanna stay-
want to know if someone's interested in either being chairman or being vice chairman, okay?
What about those?
You don't have to tell me tonight, but it would be helpful if by April meeting, you would let either me or Kate know that you would be interested in being, right? Because if, for example, if you're an alternate at the moment, you know, the select, or the board of Selectmen might need to, I need to find out whether I'm allowed to change the permanent status, or whether the Board of Selectmen have to change. In other words, let's just say, for example, that Sharon was willing to be vice chairman. I'm not suggesting you are, but if you were, you're an
She's
alternative.
an alternate.
I'm an alternate.
That's right, you're an alternate, right?
So you'd have,
Which would mean that if you're elected vice chairman, that you would automatically become a full board member.
Right.
But I don't know if the board, or if the chairman, or the select board has to make that determination first. Or, in other words, probably, it's not a big issue for them, but we need to make sure it's done correctly.
Correctly, right.
Yeah.
Is there a limit to how many full members we can have? We can only have five full members.
5 full members and 5 alternates.
we don't have any
We
alternates.
can have 10 people on the board.
We currently don't have.
Bill, that's it,
Me and
you
Bill.
and Bill, that's it.
Is it, Mark?
But she'll
Wait,
make,
how
and
is
Mark.
Mark? Yeah, Mark's an alternate.
and she'll make
Mark
the
is an
5th
alternate.
board member. Well, I don't know.
She'll make the what?
Keep rounding up the
She'll be an
I don't
alternate.
believe Mark
won't she?
serves an officer.
Remember, she's
No,
not-
Mark
she's-
can't serve
She did
as
it
an
for
officer,
3
I don't
years.
believe.
Yeah.
But she's a member.
How does she become a member? Who are you kicking off?
No. Wait,
How many full-time board members do we have? Currently?
Drew, Doug, and George, and Jake.
because Sean Bergeron resigned.
Right.
He was not replaced.
So she took a 3-year term last night. They made her a full member.
So how
They made her
did they,
what?
they made
A
her a
member.
full
So
member
how
as
did they-
opposed to,
Alternate?
did they consult with you to regard whether you wanted to elevate somebody from an alternate to a full-time and appoint her as an alternate?
Well, we still
or-
have, we would, well, that is odd.
Yes.
They didn't state what they made her, but I'm assuming they made her a member. They didn't say alternate.
Well,
They just-
member. Member doesn't mean full-time.
Three-year member.
No, We should clarify that with them, because the reality is,
I thought
you want to step down to alternate anyway, right?
but I'm willing to stay full-time if needed to give us a
And you
proper-
can, Jake,
Right.
without having to be reappointed,
Yeah.
because you don't have to be, hold on, you don't have to be
Jake's the vice
reappointed.
chair. We don't want to lose that either.
Well,
You don't have to
by
be.
going back to
If
alternate,
no
he,
successor has been appointed and qualified at the expiration of an appointed member's term, which is you, the member shall be entitled to remain in office until a successor has been appointed or qualified.
Okay, so I can stay on as long as needed until a successor is
Correct.
appointed.
That's how the RSA reads, yes.
Because I'm willing to also stay an alternate to help out when,
That would make my world.
recusal issues come
Yeah.
up.
I'd be
or
happy,
vacations.
really.
right, but my point is, that,
Big
for
all our
example,
worlds.
if Bill or Sharon wanted to be elevated to a full board member, or both of you wanted to be, we could discuss, then we'd leave Jennifer as an
We
alternate.
talked
for
about
Tom.
raising them, we talked about it back probably 3 months ago, about raising Sharon and Bill to full to full members, but Bill wanted to think about it back then,
Well,
and then it never came to fruition.
Everybody turned around.
But it never came to fruition, nothing happened.
Okay, well, the thing is, this makes a difference because we would like to have, the selectmen will meet between now, obviously,
They're
several
meeting on
times.
the 2nd.
Well,
They'll meet in 2 weeks, they
Of
just
April.
met.
oh, they just met, okay,
They
so
just
only
met
have one.
Tuesday.
So my point, though, is that particularly if either one of you was interested in running for vice chairman, not that I'm not arguing that you want to be, but I mean, if you were, then you do need to be a full board member, right? But also, it probably makes more sense to have Jennifer be an alternate to begin with, and have the two of you elevated, and then we have 5 board members, who are all, then it's
And she can learn the ropes.
the 5 of us, and Jake goes back to alternate with Jennifer. Okay?
Yeah.
It's going to be on video, Drew. And my wife's going to look at it and say, what do you nuts? But I will volunteer to be,
Yeah, okay. Well, I mean, you're here every time anyway.
Yeah.
Frankly, the alternate time is almost no different.
you're right.
Yeah, there's a difference between chairman and board member. Okay,
Jake, what are you doing?
okay, so now we need to,
Well, we're not doing anything until April.
He wants you to find out
Okay.
about, since she was an alternate, what they did, because they didn't say last night. They just,
Appoint her to the board,
right.
which then I think allows the chairman to assign her as either an
I
alternate
gotta
or
confirm that.
a regular
Confirm that.
member.
well, we'll sort that out and get that straightened out. Okay, so let's talk about the minutes. Okay, so I need Doug, George, and Sharon to look at the January 9th minutes and approve them.
I looked at them, I think they're fine.
I looked at them, I concur.
Okay, I want the 3 of you to tell Kate then that you approve the minutes.
We approved the minutes,
Approve the
Dave.
minutes.
I'll make a motion to approve the minutes
I'll
as
second.
drafted.
I'll second.
All in favor?
Aye.
Aye.
Good.
Okay, so
go.
that's taken care of. Okay, now, the January 17th minutes, Kate took time to straighten out a couple of the questions, and by the way,
Watch the tape 3 times.
the answer to the question as to the vote count, I asked Chris how we handle it when we, for example, have an evening when we have more than 5, because, one alternate was elevated for one case and another for another, et cetera, et cetera. And his comment was, he said, you can do one of 2 ways. He said, you just vote it 5-0, or if it's a particularly sensitive case, then it's best to have
Roll call vote?
a roll call vote for that section of the minutes.
Yep.
Okay? So that each section of the minutes would be voted on by different people. But he said it's probably not a good idea to have 6 people voting, for
Okay.
approval of the minutes.
Okay,
Okay?
gotcha.
So now, the January 17th minutes, do we have changes?
One minor change on page 4.
Yeah.
1, 2, 3, 4 paragraphs. Stated the exhibits do not need to be approved as they were submitted by the public.
Oh, you have to be
Take
approved
to the out, submitted by the
submitted.
public.
to, take out the,
Take to the out.
There we go. Oh, wait. I have-
Okay, anything else?
Right there, you did it.
Oh, yeah.
I got very twisted on this.
Okay, anything else on January 17th? Okay, so January 17th, move to approve, who wants to move to approve?
I move to approve the January 17th minutes
Second?
as amended.
You second?
Jake seconded.
Jake seconded.
Okay, all in favor?
Aye.
Aye. Okay.
Now,
February
this passed 5-0 because you're elevated.
I was
All 5.
Yes.
I'm not counting you, Bill, sorry. We're gonna make this,
Okay, so on the February 21st minutes, I got a one or two.
I have one as well.
Okay, you go ahead, Doug.
Page 3, first paragraph. The bridge was the least impact, should be least.
where are we?
First paragraph, third line.
Right, and the
yeah.
line above that at the
just
beginning of the
spell checked and fixed it
wetlands survey.
Wetlands,
The line above that.
I got that, wetlands. Who
The
got-
wetlands survey was approved by Ed, not, take out "and it" and put in survey.
Okay.
Okay.
Okay? Oh,
On the January 17th, Drew, you guys just passed, and we took out the "to the." Do you want me to write them as amended? We took out the words "to the." I can put that
Yeah.
Yeah.
as amended. Okay, I can do that. And then this one.
on page 3 also, Kate, just curiosity, the motion by Martin, seconded by McAllister was 4-0. Was that roll call vote, or why is it not 5-0? Or do we just have, I can't remember.
There's
Right in the
only
middle.
4.
There were only 4 of
People
us.
there.
Right,
Oh, that's right, okay.
so that, trust me, I'm
Yeah, right,
gonna go through what I went through before.
okay. Any other comments, changes? I didn't see anything else.
No, fine.
Okay, I move to approve the minutes as amended.
Second?
All in favor? Aye. Okay, so those minutes are approved. So, Kate, we're all up to date on minutes, right? Okay, now, I don't believe there's anything left on administration other than yeah, go ahead.
I just need to say, because what happened last month at the meeting, I was extremely upset when I left this meeting. Some things happened that were inappropriate, and going forward, I would really like respect, and that goes for Linda and I doing these minutes and working for these boards, because it's very difficult. And things that happened at last month's meeting really upset me, and I do not want to have it happen again. Set my piece.
I think I can speak for all of us. We are all very appreciative of what you and do up there.
Absolutely.
We know how
We've been going through a tough time,
we know
so.
how difficult it could be up there
It
between
is.
all the boards, the hours, all the logistics.
Yeah, I had 90 hours in this last pay period.
my God.
So
So
it's crazy.
we do thank you
We
for
do.
your hard work. So just
I try.
Don't know what happened, but no, you're good to go.
Amanda, you don't have to, we got to adjourn.
We have to
I'm all
adjourn.
done. I was like,
Yeah.
getting up to help her.
There being no further business
I'll
before
do
the
it.
board, do I hear a motion to adjourn?
Second?
All in
Who
favor?
second?
All in
Who
favor?
second?
Aye.
You made a motion, who second?
you can do me and Bill.
Oh,
Jake
not
and
shared, so Jake, motion, Bill, second.
No, I made the motion.
You made the motion. Wait,
Somebody did.
Sharon made the motion, Jake seconded.